We are reconvening public meeting number 195 at about 1:05. And we will go to item number 10 on the agenda, which is Legal Division, General Counsel Blue.
Good afternoon, Commissioners.
Good afternoon.
On the first item, the Mass Gaming and Entertainment License Decision, you have in your packet the final version of the Commission's written decision on this matter. And you also have two letters along with that decision from the attorney from MG&E, John Donnelly. And what you will see from those letters is that Mr. Donnelly has requested that the Commission not finalize this decision pending resolution of certain matters that are in court regarding the tribe's land and trust. I have spoken with Mr. Donnelly, and I have advised him that the Commission's decision from a legal perspective was final when it was voted on back at the end of April, and that this is simply the written embodiment of that decision that was made back then. So there would be no reason not to finalize it.
Did he get that distinction? Did he
He
disagree?
did. Yeah, oh, he did. No, he
Okay.
understood. So,
Okay.
and he appreciates the Commission's consideration of his comments and his concerns. So what we're asking today is for the Commission to approve this as the final version. We brought it before the Commission, I think, about a month or a little more ago. The Commissioners provided comments. We incorporated those, and so this has all of the Commission's comments in this version. If the Commission votes to approve this today, we'll send it around for your execution. We will supply a copy to MG&E, and we will post it on our website.
And good afternoon. If I could just add to that.
Yep.
We did discover recently that there might be one area in need of slight addition, and that is in the finance section, just to clarify some of the numbers, which are taken from the reports. So we're obviously not changing any analysis or anything of that nature. Just clarifying some of the numbers are based on the inflow situation that we didn't recognize in the decision. But otherwise, there wouldn't be any other changes.
Yeah, let me just provide more context on that. Attorney Grossman and I were talking about the specific numbers. They can get confusing when we get right to the number of scenarios and the ranges, because the market assessment was made doing a number of assumptions. I had suggested, he had suggested also, that if we approve this decision today, we reserve the right, the notion of whether it's a typographical or mechanical correction that comes directly from the reports that's already been, the reports that have already been very much in the public domain and was part of the discussion, that we do that with that caveat and come back to specifically just the market assessment numbers for modifying this written decision. Otherwise, I think it's a very solid decision.
Okay, I was fine with it. Anything else, Commissioner? No.
I have a motion, if you're ready to approve it, that you can use to move it and approve it.
Mr. Chair, I move that the Commission approve the written decision denying a license to operate a Category 1 gaming establishment in Region C as presented in the packet, subject to typographical and mechanical corrections, and instruct staff to provide a copy of the written decision to the applicant MG&E and post the decision on the Commission's website.
Second. Further discussion? I just want to clarify the point, sort of the point that Catherine made, that there has been, and with Mr. Donnelly's letter, attempted to create a link between the decision and what's happening with the tribal application and the lawsuit, the tribal land and trust and the lawsuit and so forth. And we are making the point, making it clear that those are two totally separate matters. We made a decision, and that decision was final at the time of our meeting. This is simply memorializing that decision. Whether or not anything happens with the tribe that affects us on Region C is something that we've never discussed, never considered. If and when there is a reason to do that, we'll do that. But at the moment, the two things are totally separate. One decision is made, it's final. The other is on its own track. Further discussion?
And what I noted for the record, that we'll treat a potential edit to numbers in the market assessment as a mechanical or typographical correction.
Okay, all in favor?
Aye.
Aye.
Opposed? The ayes have it unanimously.
Thank you. Mr. Grossman will take you through the slots regulation amendments and the skill-based gaming process.
Actually, Mr. kick things off.
All right, thank you. Good afternoon, Mr. Chairman, Commissioners. As you know, after we opened Plain Ridge Park Casino, we implemented a central management system, and along with that, it became necessary to make some amendments to our regulations in order to operationalize the way we work. And so working with our licensee, Penn National Gaming, and with gaming equipment manufacturers as well as GLI, we've made some modifications and amendments to regulations which were promulgated and approved by you prior to the opening of Plain Ridge Park last year. So that's what you have before you today. This is you've seen these once before informally, and we bring them to you today for a vote to begin the formal promulgation process. And again, they're really procedural changes that make the operating easier, along with how we're operating, and we can certainly entertain questions relative to what more specifics on what those changes are. But this streamlines our process. I think it makes it easier and makes some changes which are favorable to making it our regulatory model enhanced and improved.
I think it might be beneficial to talk at a high level
Yeah.
of those changes, to remind myself, my colleagues, and the public. I know that this reflects a lot more what we currently do and want to do, but if we could draw a high-level distinction with what
So
these
I think
changes.
Attorney Grossman is prepared to walk us through those,
We-
some of the high-level changes.
So I can move through some of these changes really quickly, and obviously if there's an interest in discussing in further detail, we can do that. The first page, all we're talking about is adding to the internal controls to make sure that before machines are removed from the floor and subsequently removed from the property, that they're checked to make sure there's no cash or other tickets left in there, so everything is properly reconciled. And that our seal is removed from the machine before it leaves the property, before it leaves the estate. So that's all that does. Secondly, on page 2 at the top, we just clarify that there are essentially two things that our slot approval regs discuss. They first discuss the delivery of slot machines into Massachusetts and how that is supposed to work. And then they discuss how a machine would be installed and approved for operation and modification. So those are the two categories essentially that are discussed here in section 144. And further on that page, as we have before, we discuss what an electronic gaming device is. Essentially, those are all of the devices that are covered by the GLI standards, which have been adopted by reference previously in the Commission's regulations. Importantly, at the bottom of page 2, we also, for the first time, define what a prototype is, because it's that is actually getting approved at the independent test lab. They don't test every single machine. They just test a prototype of a machine, then that gets certified, and it's based on that prototype certification that we allow all of the machines of that nature to come into the Commonwealth. So here we define exactly what we mean by a prototype. On page 3, we start getting into the delivery of machines, and there we essentially are just saying that when a gaming device manufacturer, who of course has to be licensed as a gaming vendor, is prepared to submit a device to the independent test lab, that they provide us notice of that in the event that we're interested in seeing one of these actual machines. Once the device is then certified by the independent test lab, they need only provide us notice when they're going to ship one of these machines into Massachusetts. They don't require approval at this point, as they're not going to be used necessarily in the casino or operated immediately, but we will be notified that they're going to be shipped into the Commonwealth and where they're going to be shipped. And we talk about that a little further at the end of these regulations in section 145. It's not until a little further on, moving on to page 5, where we talk about the process that is undertaken once the casino decides that it wants to operate one of the slot machines that's already been shipped into the Commonwealth. And here, again, as Mr. Glennon said, all we've really done is implemented some of the best practices that were learned during the opening of Plain Ridge Park. It's a similar approach to that, so it worked well there. It's, as I understand it, fairly garden variety in the industry as far as these types of approvals go. Essentially, the casino would notify the commission, most likely through the gaming lab or the NOC, that it intends to operate a machine. We would test it we would validate it to ensure that it works with our CMS and that it's consistent with the certification that was issued by GLI and that any other conditions have been met. Once it's been validated, the licensee is notified. The licensee then notifies the IEB, who coordinates an inspection on the floor of the device to ensure that proper surveillance is in place and that the other operational features are working properly. At that point, the IEB approves the device for use. And it's essentially the same process for moving or modifying a device as well. It's also just worthy of note, though, in the middle of page 5, that for the first time we define what it means to modify a device, and when it is exactly, then that express approval is required by the commission to make an alteration to a machine. For things like changing the payout percentage or denominations or things of that nature.
Todd, before you continue, so the statute affirmed the illegality of transporting slot machines in Massachusetts, and our approval is going to come until prior to the installation. So notification will be sufficient in the case of, is what's going on here. They will simply have to notify that they're shipping machines, and secondly, they would have had to identify a prototype, and the prototype would have to be tested by the lab?
It would have been. So the shipment of slot machines is governed under federal law as interstate commerce, and the federal statute essentially says that a state may expressly allow for the shipment of slot machines into its state, which was done by the General Court here in Massachusetts as part of the Gaming Act. At the end of the Gaming Act, it's not in Chapter 23K, but in the Gaming Act, the legislature and with the governor's signature authorized the shipment of slot machines into Massachusetts for use in gaming establishments, essentially. So it's legal for those purposes.
Okay.
It's illegal under Massachusetts law to possess a slot machine in Massachusetts unless it's approved for use in accordance with Chapter 23K. I didn't mean to say approved there. But consistent with our regulations, such shipment would be okay into Massachusetts if in accordance with these regulations, provided that proper notification is given to the commission. There's, under that same body of federal law, gaming manufacturers, slot machine manufacturers, are required to register themselves with the United States Attorney General and identify each of their machines and keep records seriatim as to how many machines they have and have shipped and whatnot. So there's a separate body of law that governs slot machines as well, in addition to this. So I think what we're doing here is in accord with that and just gives us the infrastructure to monitor these machines into the state and then onto the floor and then any subsequent modifications. So that's what this is designed to do. It recognizes these bodies of law in here. So we also cited the federal statutes as well.
Thank you.
We have one other provision in here that we've just clarified, and this is the last point I think I would just make, is that we clarify the ability of the commission to revoke or condition any approval of a slot machine for non-compliance with either the GLI standards or the GLI certification or any other operation issues. So that's an important component to this, of course, too, that we have the flexibility to ensure that only functioning machines are out on the floor. Otherwise, there are obviously a number of other adjustments in here, but I think that's the high-level overview of what we've done.
Todd, can you quickly speak to the changes under 14405, the fees for testing? We've dropped a defined amount and given us the flexibility to assess the appropriate fee to a gaming vendor.
We have rethought the process, and the initial process called for the permitting of each machine before it was sent in, and that there would be a slightly different process that would be utilized than the one I just described. Part of that initial process would require the payment of $500 per machine for a permit for that. That's a process that has never really taken foot. And so we are really just recognizing here by striking it that we're not going to assess those fees. What we may do, though, is in the event that the gaming lab desires to analyze a machine or review it for compliance with the GLI standards itself, that we may assess a fee for our time in undertaking that process.
Who is that assessment on? The manufacturer?
Yes, it's on the manufacturer. I think we clarified that point. Yeah, to the gaming vendor.
Sounds good.
Any other questions, thoughts? Do we need a motion?
We do.
This is minor, but you know, it's, I raised it before. In page 6, on subclause 4, did we change the shall when possible to a may?
Yes, I apologize.
It's okay.
I didn't mention that. The only change I'd recommend, based on an astute observation, was that we say here that on the bottom of page 6 that the gaming establishment, the commission shall, when possible, do something. Instead of saying that, we should just say that we may do it. And that's the only adjustment that I would make there.
Right.
So you need a vote to begin the formal promulgation process for these.
Yes, so
So this is step one in the process?
we've, as was mentioned, it's been released for informal comment. We
Right.
received a number of comments, but now we'd like to begin the formal process.
There's comments from
From,
licensees,
two of our
operators,
licensees who
substantive.
commented,
Yeah.
and we've incorporated most of the recommendations.
Okay.
Somebody want to?
Mr. Chair, I'd move that the commission direct staff to begin the formal promulgation process for changes in regulations to 205 CMR 138 and 205 CMR 144 is included in the packet.
Second?
Second.
Further discussion?
Which one was 144?
Towards the end, last few pages.
It starts
thought it
on
was-
page 2.
Page 2. Oh. What about 145?
Yeah. So I think it's 138, 144, and 145.
In 145. I'll amend my motion to include 145.
Any further discussion?
I second it as amended.
Okay. Further discussion? All in favor?
Aye.
Aye.
Opposed? The ayes have it unanimously. Catherine?
Mr. Grossman is going to provide an update on the skill-based gaming.
And again, I'll turn over to Mr. Glennon to kick off this subject.
Thank you very much. So we have, we started the process of developing some regulations of our own to encompass skill-based gaming. And during that process, we became aware that GLI was undertaking a rewrite of their GLI 11 standard, a full rewrite to include language that takes into account skill-based gaming. And so we decided to wait for GLI to issue that. They have issued a draft for public comment that is in your package today. And there's a considerable amount of changes to this that take into account skill-based gaming, how it would be tested, and this is certainly a conversation which we can continue today or talk about at more length, but I think there's some interesting components to that. What we're waiting for is for this to be finalized, and then we will come before you with recommendations to modify our existing regulations which adopt the GLI standards to move from version 2.1 to version 3.0. We have had conversations with manufacturers, including Gamblet, and also with GLI, and given them our comments about the draft, and had some long discussions with Todd and Floyd and myself, and certainly would entertain any questions relative to that process and what we're doing.
So we believe that this will eventually make it into a regulation or a reference from regulations?
So we adopt by reference GLI standards. GLI 11 version 2.1 is one of those which we currently adopt. It would be our intention, I believe, to revise that to adopt this newer version of the GLI 11 standard, which includes all the language relative to skill-based gaming.
Do other jurisdictions do pretty much the same thing? I mean, are New Jersey, Pennsylvania, are there?
Yes, so about around 60 to 70 jurisdictions adopt GLI version 2.1. And about a month ago, GLI sent this draft version out to all those jurisdictions, and they've had the opportunity to comment on those. And it's going to take a matter of maybe 2 to 3 months before GLI finalizes those comments from each regulatory body and encompasses another update, a final version of GLI 11 version 3.0.
So I have not read this. So will this be the totality of the regs relative to skill-based gaming, or will there be other dimensions that aren't covered in the GLI draft?
So essentially, it'll encompass nearly all of the slot regulations. Any machine that you see on the floor within a licensee in Massachusetts, GLI 11 encompasses that fundamental gaming device, whether it's an electronic table game or a slot machine. So it includes everything on top of the addition of our new skill-based requirements.
So what's in the packet, it's only the skill-based requirements, right?
Sorry, can you repeat that?
What's in the packet, GLI 11 3.0, that's only the skill-based portion?
It's actually everything.
Everything.
It's the full revision of 2.1. So they took the 2.1, which we adopt, they've reorganized it, made some changes to the way it reads through, and included language relative to skill-based gaming, and also opened up some language to allow for inclusion of continued innovation in the industry, I believe, I would say.
So we would be doing this whether it had skill-based gaming or not, essentially?
I think so,
Yes. The last update for GLI version 2.1 was released in 2011, and it's essentially future-proofing the regulations for new product that gets released into the field.
And as of this time, I believe only 1 or 2 manufacturers have submitted a skill-based game for testing to GLI at this point. So there really isn't a lot that's ready for prime time at this point.
So refresh my memory, when we had the discussion about skill-based gaming, and was it via regulation?
we came up with a draft, you'll recall, of
Yep.
skill-based regulations. At the time, GLI hadn't released any draft. We
these.
didn't know what it may or may not entail or how long it would take or anything like that. In the interim, they released this draft, which incorporates the skill-based provisions as was just described, many of which are similar to the ones we previously released. So and see if we could just coalesce with the other jurisdictions around this standardized type language. Of course, it's all subject to the commission's acceptance and modification in any way.
But those regulations are effectively on hold?
On hold. And we may never move forward
may
with
never
those
move
if we like what's in GLI 11.3.0, and you'll see, again, a lot of the same subject matter, then, yeah, we would never adopt those other ones.
Fair enough.
You mentioned manufacturers weigh in, other jurisdictions weigh in. How often do gaming companies, our licensees, weigh in on GLI standards, if at all?
And essentially, every version that comes out, they have the opportunity to, along with the regulatory bodies, the licensed vendors, will provide comment for every revision of this standard.
And of course, even once it goes through the full GLI process, if the commission elects to seek to adopt it here, it would go through another public comment period, so all of our stakeholders can comment on it again, if they haven't already.
Sounds good.
Yeah, so there's nothing for us to do at the
No,
moment, right?
informational only.
Yeah, okay. All right, item D.
Item D is a small business impact statement. This is for 205 CMR 138, Uniform Standards of Accounting Procedures. And as you may recall, we did an emergency amendment to that regulation to address the ATM concerns that we had at a prior meeting. So this is just the first small business impact statement, so we can start the formal process to implement this in the regular course.
Okay. Have a motion?
I move that the commission approve the small business impact statement for 205 CMR 138, Uniform Standards of Accounting Procedures and Internal Controls as included in the packet, and authorize the staff to take all steps necessary to file a small business impact statement with the Secretary of the Commonwealth and proceed with the regulation promulgation process.
Second.
So this is to prior changes, not just the ones that we just did, right? It happens to be the same section, 138.
Right, that's just coincidence.
Yes, this is just for the
going to-
ATM
Because
changes,
this
yes.
is just the ATM
Yes,
changes.
that's right.
Further discussion?
I wonder how you keep it all straight when you do all those submissions.
Right.
We'll be back
Council.
for the next set of changes with another small business impact statement.
I know.
Further discussion? All in favor?
Aye.
Aye.
Opposed? The ayes have it unanimously. Thank you.
Thank you, that concludes
Thank
legal.
you.
Mr. Chairman, I understand.
Director Wells, are you prepared to
Yes,
do
I think she is.
item 9?
Yeah.
And we still have Janice? Are you looking for Alex? Okay. Okay.
Huh?
Well, we'll do this. It's
Yeah,
pretty
this
short.
one's quick, so.
Okay.
Yeah.
Good afternoon, Commissioners. On the agenda today is a proposed emergency regulation change for 205 CMR 134.13. This proposed regulatory change would make the fingerprint requirement for non-gaming vendors discretionary as opposed to automatic for that lower level of vendors that are doing business with the casinos. As a result of our operational review in licensing and IEB, this is an area where a regulatory change is recommended. It was obviously overly burdensome to have all officers and notable employees be fingerprinted at that non-gaming vendor level, especially because these are the applicants for registration, not licensure, registration, who are not providing gaming equipment in any capacity, and who are not having a significant impact on casino operations. And we have found the current practice of having a single representative file the fingerprints with the commission really doesn't result in any substantive benefit to the investigation, particularly because it's easy for the applicant to designate that representative someone without a criminal history. So, short, in a colloquialism, we're not getting a lot of bang for our buck with that provision. So going forward, under the proposed change, we will be focusing on the entity and then only requiring fingerprints when concerns are identified using a risk-based approach. So we take a look at the company. If there's any concerns, then we can require the fingerprints if that is applicable in the particular investigation. Notably, we're not aware of any other states that have this type of fingerprint requirement for this level of vendor. I did speak with counsel at Fox Rothschild and confirmed this understanding. Pat Mandama had the same understanding as well. And I have Director Connolly with me here this morning. He can speak to the commission as to the operational impact that this proposed change would have going forward, because this really came from talking to the vendors, seeing where the pain points were in the vendor registration and licensing process, and he's had a lot of contact with the vendors, and I think he can speak to that, and operationally the impact that this change would have.
Thank you, Karen. As we have done, as Karen mentioned, started looking through our the regulations. Wait, I'm sorry. As Karen mentioned, we've been looking through both the regulations as well as our internal policies and procedures, and this was an area that really stood out for all of the reasons, not only that Karen mentioned, but also the fact that it's a heavy lift, to put it lightly, in terms of the registration process. We have a lot of businesses, some small, some medium, some large size, but for each one of them, it does require them taking time out of their day to come in and get printed, and particularly where there's not much bang for the buck, it seems like an area that's ripe not only to save time at the commission, but also on the part of our registrants, reduce their burden because we're not getting that bang for the buck again. So we think it was something that makes sense right out of the gate. It also brings us in line with other jurisdictions. It's something we've heard from our licensees in terms of a change that they would encourage, and so we wanted to be receptive to that as well. What the real world impact is that, anecdotally, I don't have statistics, unfortunately, but I know anecdotally from talking with staff that, a lot of vendors, and by a lot I mean somewhere close to half, at some point in time have to change an appointment, have to, miss an appointment, have to reschedule, because it is difficult for them to do. So there's a lot of churn in terms of time, not only on licensing staff, but on whoever's going to conduct the fingerprinting that would be able to save, and again, save time on the part of the registrant. So it will have an immediate impact on our operations, and I think in terms of those vendors who will be coming through the registration process.
I agree entirely for all the reasons you state. You retain the discretion, and you can take it as you see fit. So I would be all for that. I wonder, though, if the same discretion could be placed on the employee registration, because currently every employee would have to come, even if they're just a service employee, right, who only gets registered, who gets licensed or can go to work as soon as the registration is complete.
And I think one of the,
Do all of the arguments that you make transfer to the service employee?
No, I would not make the same recommendation for the service employee, because what we're registering really is an entity, as opposed to with the registration, we're registering a person to work at the casino. And as far as having the comprehensive look, the required look at the criminal background check, I wouldn't just rely on not having the backup of the criminal fingerprint check. So that I wouldn't recommend that.
Anything else?
I think this move is well thought out. I've been with Paul, and we've been down at Plain Ridge and, trying to get companies to come in there thinking about doing business. The fingerprinting was just kind of an extra layer, and oftentimes it was the sales agent or, the point person for the relationship that was coming in doing the fingerprints. I agree, I don't think you were necessarily capturing the information you were looking to capture. It is an extra, I don't want to call it an inconvenience, but you can't just run down to 7-Eleven and get your fingerprints and hand them in. You either have to go to a police station, or you have to do it through one of our entities. So I applaud the changes that you made. I just had one quick question, kind of above, and maybe it's more of a clarifying change. You've added language in there about each qualifier for a gaming vendor. Is that a clarification from what
Correct.
it?
That's
Okay.
what was happening in practice. We just wanted to make sure it was clear in the regulations.
Okay.
So does the statute require, what does the statute require in terms of
The non-gaming. vendor?
background for the gaming service employees?
I'm not,
Offhand,
I
don't-
would have to look at that and
Yeah.
have to
What
come
was the
back in
question?
another day.
What is the statute require for the gaming service employees, for the registration?
I'd have to come back and check.
So we did by regulation the fingerprinting?
Yes. Because this even
'Cause we're-
even
we're-
this
it-
has it right in here.
Yeah,
gaming
which is
service.
the current,
Yeah,
which
yeah,
is not being
right.
modified.
Right.
Right,
But I'm following the same sort of
right. No, we could,
parallel to, if there is a case to be made that there's parallels between vendors and employees and level of risk, if we're implementing a risk-based approach,
Right.
I'd just like to explore the level of burdensome that we put on service employees, registrants, as well as our own operations.
Right.
yeah,
and
but that's, the burden, I don't think, on the employees, it's different for vendors, because employees are going to be at the facility anyway, and when they go through the HR process, and we have the state police right on site to do all that, so it's not quite the same as a company that's coming in and looking to do business, because there's already that nexus with the casino, and they're already on site, and it's a minimal effort on behalf of the employee, as opposed to a vendor, which would have to designate someone, send someone in. That's where the logistics is very different for an employee as opposed to a vendor.
Right. And as Karen had mentioned before, one of the things we talked about a lot was the relationship. I mean, there's a direct relationship, commission registers or licenses an individual employee, but with a vendor, it's an entity. And so what we're trying to do is acknowledge that there's not one individual person who stands for that entity. And so, as Karen mentioned, they might put someone forward who is highly likely to pass, but is not obviously representative of the company. So what we said is, let's take a focus on the entity, which is what we're really concerned about. And on the employee side, it's a direct one-to-one relationship, which that was one of the things we had talked about as we considered this change, why it made sense on the vendor side.
Yeah, the issue of whether or not to change other things for other categories isn't on the agenda, and we probably technically can't spend too much time talking about. But we will have other bites at this apple. IEB, as you know, is reviewing a lot of stuff, and will make a recommendation on these issues to us, and we will then talk about it and decide whether we agree or not. So there, and I mentioned, I'm not sure you were in the room, but I mentioned to the licensees that you've undertaken this process, and that we're going to be anxious to have them weigh in as well as this process unfolds. So there'll be more bites at this apple. Okay, other comments on this proposed change? Do we have a motion? Commissioner Stebbins?
Are we adopting this by emergency? Mr. Chair, I move that the commission adopt, for emergency purposes, the included changes to 205 CMR 134 with respect to fingerprinting.
134.13, right.
Correct.
Second.
Further discussion? All in favor?
Aye.
Aye.
Opposed? The ayes have it unanimously.
Thank you.
Thank you.
All right.
Thank
We are now going to item 8. 8?
Yes.
Yeah, 8. Racing Division, Director Lightbound, and guests.
Good afternoon, Commissioners.
Good afternoon.
So our first item under racing is the local aid payments, and Doug O'Donnell will address that issue.
Good afternoon. What you have in front of you is the memorandum for the local aid distribution, the quarterly payments made to the tracks where racing is conducted. It's based on, it's 6 month in arrears from the time the payments are made, which this would be the June 30th payment. Total amount is $180,970.07. And on the following page, if you have it in the packet, it'll have the breakdown of the handles from October, November, and December of 2015. And the payments go to Boston and Revere, Plainville, and Raynham. And we do need a commission vote on this to approve it.
And these are the ones that come out of the handle, right? You mentioned these, the 35%.
Yes, correct. It's 0.35% of the total handle, which is distributed to the cities and towns.
Right. Now, there used to be an appropriation for these purposes. This is not related, right?
Correct.
This says amount wagered, so that is amount wagered, not amount lost. That's
Correct. That's the handle. That's
like GGR,
Yes,
comparable to gross gaming revenue.
yes.
Yeah, okay.
And it's both, it's for all handles, both on-track and exports as well.
Right. Is there anything significant about this number? Is it up, down?
Now, it's, in comparing it to last year's number, last year for the same time period was $155,335.
Wow. So the handle is up
It
by,
bumped up a little bit from last year, yes.
by quite a big percent, actually. Other questions, comments? We don't have Commissioner Cameron for a motion. Somebody want to pick it up?
I'll be happy to move, Mr. Chair, that this commission approve the local aid quarterly payments for June 30th of 2016 for a total of $180,970.07 to the cities of Boston, Plain Ridge, Raynham, and Revere in the manner that is broken out in the packet here today.
Second?
Second.
Further discussion? All in favor?
Aye.
Aye. Opposed? The ayes have it unanimously. Okay. Item 8B, Brockton Fairgrounds request for racehorse development funds is next. I just want to say one thing for the record. One of the interested parties here, Mr. Carney, called me yesterday late afternoon, and I took his call, and he said that he had heard rumors that the commission would be declining his offer, his proposal, and that if it would be easier for us, he would be happy to withdraw it if that were the case. I said nobody can know whether or not the commission will approve or disapprove this proposal because the commission has never discussed it. None of us knows yet, prior to that discussion, where we're going to come down. If he wanted to withdraw it, he was welcome to do so, but otherwise, we would deal with it up front and make our decision, and if we approve it, fine. If we don't approve it, fine. And he said thank you and decided to leave it on. We did not discuss any of the particulars of the proposal. He did not lobby me one way or the other. I also asked him about whether he had an opinion about the racing reform legislation, which is up at the State House. The Senate has passed, I think is in conference right now. He said that he had thought about it. He was immaterial. He was not opposed to it. He was fine with it. If it went through, he was fine with it. If it didn't go through, and that was the end of our conversation. Okay, Dr. Lightbaum.
So during this discussion, I'll probably use the word Brockton instead of Middleborough. It's the actual Middleborough Agricultural Society who's requesting it, but it's would be run at Brockton, and so typically we just call it Brockton. So I want to make sure everyone realizes that's interchangeable. So the president of the Middleborough Agricultural Society, Robert Kelly, has submitted a request for $2.5 million from the Racehorse Development Funds to use for purses for the planned 15 days of racing. They're estimating maybe 10 races a day, and it'll come out to more purses than what, purse per day than what Suffolk used to offer when they ran a full meet. That was a couple of years ago, so with inflation and the need to be able to draw the horses and all, that's probably a reasonable figure. They've also requested $262,000 from the Racehorse Development Fund for the Massachusetts Thoroughbred Horsemen's Association to cover administrative costs. And as you all are aware, you recently approved the Suffolk Downs request for $225,000 for the New England HBPA for their costs. So again, the costs are fairly comparable. I want to mention also that Mike Marizio with the Carneys is here, as well as George Carney and Bill Agoria from the Mass Thoroughbred Breeders or Horsemen's Association are here too if you have questions. Mr. Kelly also requested $1,473,947 from the Racehorse Development Fund for administrative and operational expenses. They're not going to simulcast, so they won't have income from simulcasting to use towards these costs. In looking at this issue, there's a couple of different things, as you all are aware. The Chapter 23K, the gaming legislation, which addresses racing, and then also the racing regs 128A and C. So under Chapter 23K is where the Racehorse Development Fund money is addressed, and just paraphrasing it, the 80% from the funds approved by the commission would be deposited weekly into a purse account established for the horsemen. The amounts would be combined by the licensee with funds from existing purse agreements to fund purses for live races. So right there, it talks about using the Racehorse Development Fund for purses. When you go to racing legislation, in 2015, the Acts of 2015, Chapter 10, added wording that allows monies from the live and simulcast handle that would go into the purse account to be used for administrative and operational expenses. However, in speaking with Catherine Blue and reading the statute, we determined that this didn't include necessarily the Racehorse Development Fund money. So my recommendations were that the commission approve the request for the $2.5 million from the fund for the purse money. That seems to be fall in line with what they're intending to do. The commission approved the request for the money going towards the Thoroughbred Horsemen's Association's administrative costs. Again, that seems consistent with what's been done in the past. But then that the commission denied the request for the administrative money requested to run the meet. And now, if Catherine Blue wants to add something to that, she may.
I think Director Lightbaum and I have looked at this in detail, and we've had several meetings with the folks from Brockton. We've given this a lot of thought, and have also taken a long look at the statutes. And one of the things that, really came out to us was that the legislature was very specific when they amended 128A and 128C to talk about operations and administrative expenses. And they amended certain provisions of the Racing Act to do that, those particular provisions that dealt with premium, simulcast, and live handles. They did not go and amend the Racehorse Development Fund statute in a similar way. And so it seems to set up a situation where the legislature assumed that some other streams of purse monies could be used for those expenses, but then we have purse monies under the Racehorse Development Fund that seem primarily dedicated to purses. And I think that falls in line with what we've seen in other jurisdictions that have taken gaming money and have wanted that to supplement purses so they could help the industry grow. So having looked at all that and, met with the folks from Brockton and thought about it, I support Director Lightbaum's recommendation. I think legally that, passes muster. It is a very difficult, obviously, decision to try to make because, we understand the folks who are involved and the, the passion for what they want to do. But we think that that recommendation is the legal recommendation.
Thank you.
Excuse me one sec.
Yep.
I wondered whether the proponent wanted to.
That's exactly what I was going to ask.
Okay.
I did want to ask Mr. Carney or Mr. Mauricio, the recommendation is to exclude a significant portion of the budget that you had here. It includes $1.4 million that we would not be agreeing to if we side with the recommendation. Can you run the meet without that money, plain and simple?
Yeah, let me first say, Commissioners, that we've enjoyed working very closely.
Hit the little button on the bottom.
We've enjoyed working very closely with staff. Commissioner Stebbins has given a lot of help and direction, and so hasn't Commissioner Cameron. A lot of that has been working with the Mass THA to get us to this point. And Catherine Blue, Attorney Blue, has been very helpful, and so hasn't Director Lightbound. So we really appreciate all the work that everyone has done thus far to try to bring us to the point where we can help revive racing in Brockton and racing, live racing, thoroughbred racing in the state. And if the commissioners recall, we originally applied for and received what we've all called a placeholder license last fall. And we did that because we did not want to compete with Suffolk Downs if Suffolk Downs had decided to apply for and receive a robust racing schedule. The economics of it just don't work to have two racetracks with aggressive racing schedules operating at the same time. So we've taken a second chair to Suffolk Downs and waited to see what their plans were and how it all played out. And as the commission knows, Suffolk Downs has elected to run a very small, brief schedule of just a few race dates. And so it's for that reason we said, fine, we will step up and bring back racing and support racing in the state in every which way we can. We don't expect to make any profit from the operation, especially in the beginning, because it's very, very expensive to bring back racing in a location that it hasn't had racing for now some 15 years. I'd also like to say that Bill Ligorio of Mass THA, the president, has been a tremendous help. He's really, if anyone, has excelled in making today or bringing us as far towards the potential of bringing racing back. No one has done more than Mr. Ligorio, and he's provided a tremendous amount of support and information to get us to this point. Now, I know that's a long introduction to really answer your question, Commissioner, but I have to say we're a bit surprised by hearing that recommendation, that it's legally not possible to provide these administrative and operating expenses after having spent all this time. We didn't hear that before. We heard certain categories of costs might be difficult, but that administrative and operating expenses are allowed. So I can't say that we came today, with a thorough analysis of why it's not, but let me just say this. If the New England HBPA can receive funds for administrative and operational expenses in support of horse racing, and if the Mass THA can legally receive the same funds, then the track can as well. Because there's nothing in the legislation that says only the Horsemen's Association can receive those funds. It says that the funds are to be used for administrative and operational expenses in support of horse racing. That's what the language says.
That's with respect to the
Takeouts.
contribution to the fund for the various takeouts.
From the horse racing or from the horse development fund, from the fund that we're talking about here today.
No,
The same fund that we're asking that administrative and operating expenses be dedicated where those operating expenses are actually at the racetrack, which are the most important operational and administrative expenses to make racing possible.
But that's not what Chapter 10 does say. What Chapter 10 says of the Acts of 2015 is just what the chairman said and Council Blue said, which was operational costs to the associations would be allowed, but from the takeouts, from those monies, not from the Racehorse Development Fund.
Well, as I said, I'm operating from memory. I didn't come here prepared, but my memory suggests that the language was broader than that. That if it's for administrative and operational expenses to support horse racing, then that's what the money's for. I would think from the larger legislative purposes of that fund, it is to bring back horse racing in this state. It's to support the horse racing industry. The horsemen's associations and the tracks are very vital. They're very important. But they're not the heart of the industry. The heart of the industry is the horses themselves and really the patrons. Because if you don't have the horses and you don't have the patrons, you don't have a horse racing industry.
But we understand-
Also, if you don't
we-
have a track, you don't have a horse racing industry.
We absolutely understand that, but right now, and I will say, I thought that previously the conversation had been about what kinds of expenses and in effect how much might be allocated out of the Racehorse Development Fund. And there was a question like, is there a capital cost? That doesn't sound like it ought to be involved. What's a capital cost? What's an operating cost? How much seems reasonable in the context of our experience and what we know? I was surprised actually to see just the flat-out preclusion that this was not something we had the authority to do, so the discretionary questions about how much and what kinds of expenses were irrelevant. But apparently you hadn't heard this before either. So
We
I'm
hadn't
wondering,
at all.
but I know you guys have talked, do you have a different view of that? Because that's a really.
No, Mr. Maurizio has not been part of many of our conversations.
Oh, all right.
So that would be why, Mr. Maurizio is here kind of on the spot today. These are conversations that we've had with various members of the Brockton team as we've met with them over time. We've also, we reviewed various proposals from them when you approved a license for them back in the fall. The proposal was different than it is now. There was a purse money and there was a percentage that was going to the track. Director Lightbaum and I looked at that, thought maybe there was some flexibility in a proposal that looked like that. We also wanted more information on whether they were going to simulcast at the fair because they can, and what was going to come of the money that could come to purses from the live handle and where that money was going to go. So as we've had more conversations and understood better what their proposal was, and their proposal has been refined over time, this has informed how we viewed it against the law and the recommendations that we've made.
General Counsel Blue, what is the operative language in the statute relating to the Racehorse Development Fund that apparently is being interpreted to exclude the application of racehorse development funds to operational and administrative expenses?
So in 23K Section 60, and the chairman has a copy of it there, the 80% language talks about it goes to purses. It gets paid to the licensee, goes to purses, gets commingled in a purse account, and then is paid out. And it just says pursuant to a horseman's agreement. Historical practice under 128A and 128C, there was language similar to that, and that's been how people have worked at the track under the racing statute for a very long time. Last year, the legislature specifically added language that said you could use purse money for operational administrative expenses. But in going back and looking at 128A and 128C, that operations and administrative language has only been inserted in certain sections. And in fact, it's only been inserted in the live handle section, I believe, just for thoroughbred racing, not for harness. And in the simulcast, it's all for thoroughbred harness and the greyhound simulcasting. So, the legislature was very specific about what they wanted to do and conformed the practice into the statute under the racing legislation. They did not make a similar change to the Racehorse Development Fund. And Racehorse Development Fund is a gaming statute. It's applied differently, and it was enacted for different purposes.
So the language which permits the use for some administrative and operational expenses, it doesn't refer to the Racehorse Development
No.
Fund. It only refers to that takeout that goes to purse accounts.
It only refers to takeouts under 128A for
Right.
simulcasting, for premiums, and for live handle.
Right.
If I may,
Sure,
Mr.
yeah.
Chairman, thank you for reading that because it refreshed my own recollection of the statute. I've been doing this now for the Carney family for about 20 years. So I'm familiar with the history of 128A, 128C, and how things have operated over that period of time, although we haven't been in the horse racing side of the industry. The commission's authority is to approve what comes out of the purse account. That is even before Chapter 23K was passed, under the old Racing Commission, which I was before hundreds of times on issues of purse account payouts, when we were running the live dog racing. There is no language or practice that says, over the 20 years that I've been involved, that the commission can only allow purse account money to go to, whether it's dogmen or horsemen, and the Horse Racing Association. What has always happened before 23K was passed is that there was a purse agreement of some form that was approved by the Racing Commission. And the purse agreement itself talked about where the funds will come out of this purse account and how they'll be paid. And the Horsemen Association, I can't say how they operated, but you can look at their current agreement, which basically says funds out of the purse account will come out of the purse account and they'll receive a certain percentage. And the old Racing Commission would simply approve that. Now, that's also before there was a Chapter 23K. That was before there was a Horse Racing Development Fund. And that was before the legislature just passed that new legislation that you're looking at in 2010. The legislature is
You mean
presumed
2015, yeah.
2015, I'm sorry. The legislature is presumed, when they pass a statute, to understand the existing law and how it fits in. If the legislature wanted to restrict the Gaming Commission's authority to what it could approve purse account monies to be used for, it would have said administrative and operating expenses of the Horsemen's Association only, or it would have said some other restriction. All it did in that statute is say purse accounts can be used to support administrative and operational expenses for horse racing, which obviously the
But that says
legislature...
you're talking about purse accounts.
Yes, in
Now-
other words, the
now we're
money
talking
comes
about-
from the fund to the purse account.
Right.
And then out of the purse account for what purposes? The existing law already says it goes to, in this case, the horseman, but this 2015 amendment said it can also go for administrative and operational expenses, without limitation that it's only those expenses of the Horsemen's Association.
But that's not the issue that's on the table at the moment. You know, we're not debating that the question is the source of that distribution.
Not the flow.
And the source of the distribution in our staff's reading is, in that amendment, is the takeouts that go to the purse account. So portions of the takeouts can be utilized for administrative purposes, which is presumably where this 262 and the whatever it is are coming from.
And that's exactly my point. And what I'm saying is we're calling them the takeouts under that 2015 statute. The legislature did not limit what the takeout could be used for, except
is
to
there-
say operational administrative.
Okay, let me.
Isn't it effectively limited by the takeout?
How much? What is the takeout? What
Well-
portion of the Racehorse Development Fund? What portion of the purses, I guess it is, the purse account, comes from the various takeouts, as opposed to the portion that comes from the Racehorse Development Fund?
Well, I think it probably
It
depends
depends.
all the time, but you have the casino slot money, as the commission knows, that goes in the Horse Racing Development Fund. From that fund, it goes into the purse accounts as the commission decides what percentages will go to harness racing, what percentages will go to thoroughbred racing. But also, keep in mind now, because to some degree, I would hope the commission would recognize that it should look at this in a consistent way. The simulcast
Let me just,
premium-
we're talking past each other, and this is I know this is complicated, but I'm looking at Section 60 of 23K, and it talks about the 80% that goes to purses, essentially. And the language is clear. The language says, the licensees shall combine these funds, that is, the racehorse development funds, with revenues from the existing purse agreements, which is the takeout money.
Simulcast takeout, Mr. Chairman?
Yeah. To fund purses for live races consistent with those agreements. So the Racehorse Development Fund portion of the purse agreements is to be used to fund purses for live races. That portion of purse agreements which comes from another source can be used for administrative purposes, but not the source, not money in the purse accounts which come from the Racehorse Development Fund.
I think what the difference here is the commission is viewing the purse account as a separate stream of money, and the Horse Racing Development Fund is something independent of that. Taking the chain of payments in reverse order, and using horse racing as an example, the horseman, runs a race, and let's suppose it wins the race. How does it receive its purse money? It only receives one purse check, one payment, and it comes from the track out of the purse account. The track doesn't have two sets of books, shall we say. One is funded with takeout money, and one is funded with horse racing development money. All sources of revenue come into one pot, which is we've all called, for 20 years that I've seen it, the purse agreement. And then the purse agreement is used to pay out to the horsemen.
Okay, let me just, this is going to take us a while, but we don't want to kick this, we got to resolve this. I would be interested in having a conversation, if we do have the discretion to use this money for these purposes, I'm interested in the conversations, pro and con, about why that is or isn't a good idea. But we can't get to that until we can agree whether or not we have that discretionary authority. So let's focus on this. So you've got the purse agreements, which is the distribution vehicle, is what I heard you say.
Yes.
Into that purse agreement, if I'm hearing this right, and please anybody correct me if I'm hearing it wrong, into this purse agreement comes money from the Racehorse Development Fund, which is the 9% from the slot parlor right now, and a variety of takeouts from simulcast, et cetera.
Correct.
Together, that creates the purse agreement, the purse account, purse bucket,
Funds the purse account.
purse
Funds.
account, yeah, funds the purse agreements, right? And the purse agreements are subject to a variety of limitations on distribution. Some of the purse agreements can go to administrative expenses because 128 and 129 say that that portion that comes in from the takeouts can be used for administrative. But that portion which comes in from the Racehorse Development Fund, which is in our statute, is not authorized to be used for administrative. And it looks to me like that's pretty black and white. And if somebody disagrees with that, and if we need to adjourn or go to another topic for half an hour, if somebody wants to go look into that, I'm happy to wait, because we got to get this resolved, and this is a big, important issue. Bill?
Mr. Chairman, may I say something?
Sure.
I attended every meeting with Attorney Blow.
Could he
and,
identify
Yeah, why don't you identify yourself and just
Come
up and
to the
grab
mic.
microphone.
take a mic, yeah.
Thank you. William Ligorio, I'm president of the Massachusetts Thoroughbred Husbands Association. I just wanted to add that I did and have attended every meeting with Attorney Blue and with Dr. Lightbaum. And I can honestly say there was no point in time where I was told or instructed that that money could not be used for administrative and operating expenses. We did talk about limitations as far as capital expenses versus general operating expenses, and possibly limitations to amounts. But it was never said to me, and I attended the last meeting with Chris Carney, myself, and George Carney, that that money could not be used. And we started under that premise. We went forward from the beginning, understanding that we could contrive some operational monies from this. So this interpretation is new to me, and I have not missed anything along the way. I will say, as far as racing goes in the Commonwealth, we've lost perspective on how purses are earned, because if we had no Racehorse Development Fund, they're earned from simulcast revenue and from live handle revenues. And we all understand that. Our goal, of course, is to return racing, but at no point in time we would not be this far if we were told at any point in time that, from a statutory standpoint, that money could not be used for some administrative and operational expenses.
But there's a difference in the administrative expenses that we've understood here, which is the association's expenses and the track's expenses.
But we're not to that issue yet.
What?
This is saying Racehorse Development Fund can't be used for either one. Can't be used for either one. So that's what.
That's what I'm saying, that's new to me, because I've never been,
Okay, well.
never led
there
that
is-
direction.
There's two issues. One is, is this new to the table? That's interesting, but not really in the long run relevant. The question is, what does the law say? And the law looks, like I'm saying, if somebody wants to go read it differently to me, I'm happy to hear it. But it looks to me like the language of the law says that that portion of the purse agreement account, which is funded from racehorse development funds, maybe we missed this for a while. I don't know. Did we miss this for a while?
I think, Mr. Chairman, as their proposal has evolved over time, Director Lightbaum and I have been trying to think of ways, quite honestly, to be as flexible as the commission could be within the law. And we were hopeful that we could work something that maybe would pass muster. As we looked at it closely, as the numbers got larger, as more of it was devoted to the track and, and less to the horsemen, we took a closer look at the statute. And in looking at that, thought, we have to be upfront with the commission about what we think your discretion is and what isn't. So I would say yes. Has our thinking and review evolved over
Okay.
time? Yes. I think generally in the industry, there's been a lot about operation and administrative expenses, and everyone's thrown that around. I think there has been some sense that, well, this is what Suffolk does, but upon a further review of Suffolk's agreement with the horsemen, what we understood was that Suffolk is using simulcast monies under 128A and C to fund their operational expenses. So I would say we learned a lot, Director
Okay.
Lightbaum and I,
All right,
as we
well,
went through the process.
We did have that discussion at one of the later meetings, that was what the difference was that Suffolk was using money under 128A and C, the simulcast money, to fund the operational expenses, and this money was going to be coming from the Racehorse Development Fund. The other money doesn't go through the commission. The Racehorse Development money does come to us and then is given out.
Yeah,
Has this interpretation of the Racehorse Development Fund statute been shared with Mr. Maurizio or Mr. Carney before today?
With Mr. Maurizio, no. With Mr. Carney, Alex has just described the conversation that we had, that there were different sources of the funds, that different statutory sections were amended, and that we were looking at that to try to determine what that meant.
We've all, frankly, I think, been trying to figure out a way to be as flexible with these monies as we can. And to make that point, by the way, the legislation which is in the conference committee right now makes it absolutely plain that the commission would have authority to use the Racehorse
Yes.
Development Fund for this kind of thing. We want to be in the position to fund smart strategies that might bring this industry back. Is yours one? I haven't got to that point yet, but we want that flexibility. That's why we've expressed support for that legislation. And the legislation, we knew that it was messy, the authority we had over the Racehorse Development Fund, which is why we've been actively trying to get this bill passed, so we would have the flexibility to do this. Go ahead.
Mr. Chairman, let me just say this much. Again, I've been working with especially 128A and C now for 20 years. I feel very confident, based on that 2015 change in legislation, that what we've advocated as your authority is exactly that. So I would ask the commission to consider putting us on the agenda for your next meeting, to give us time to put together our explanation as to why, as government lawyers will say, the color of money, once it goes into the purse agreement, is one fund. There's no maintenance of different color of money in that purse agreement, one being development fund funds and the other being simulcast premiums. I would also point out, for the commission's consideration, that the simulcast premium statute under 128A, section 128C, clearly says the same thing, that those simulcast premiums are to go into the purse account. They cannot be diverted statutorily without going through the purse account first. And so if the commission could authorize, even if you want to consider that the color of money doesn't change once it's in the purse account, if if you could authorize simulcast premiums to come into the purse account and then out to the track, when there's really no legislative authority for that, I think there is certainly authority to allow horse racing development funds to do the same. So I would simply ask, be put on the next agenda, give us the opportunity to more thoroughly
Well,
explain.
let me, we may have to do that. I hate to do it for lots of reasons, and not least, our next scheduled meeting is not until late August, but we can change that if we have to. But let me ask a different approach here. How much money is in the Racehorse Development Fund at the moment that it comes from takeouts? Let's assume,
There's no
There's
money in the
nothing.
racehorse
There's
development
It
fund.
does-
no.
I'm sorry, I
In the per-
apologize.
In
the
their,
purse
in the purse,
in their purse account, because they haven't raced, there is no money in their purse account, I believe, at the moment.
Okay. Okay, so
There's nothing.
it would only be the proceeds.
Now, there's a
from the
further
existing-
complicating factor because they don't intend to simulcast at Brockton.
That's
So-
our understanding, that's
So
right.
whatever is coming to their simulcast license into Raynham is already funding your operations
But
in
what's,
Raynham.
what's the,
Excellent point, Mr. Commissioner, because there will never be, even if we were racing under current law year-round in Brockton, the so-called simulcast takeout
Right.
funds, because we're not the host track for thoroughbred racing. Suffolk Downs, technically, so
Right.
long as they continue to have a license, is the host track under thoroughbred racing. There's a statutes that never been cleaned up.
Right.
So that's another reason to understand that
Well,
the
that would lead me to ask, why aren't you simulcasting in Brockton?
Well, we made a business decision that we need to walk before we run, that we need to focus on the live racing product. We need to focus on bringing the patrons back and getting that part of the operation solid, accepted, embraced, and growing before we get into the tangential issues such as simulcasting or more food and beverage services, all these other things that makes the operation more effective. You have to start, though, in our view, with the core service, the core operation, which is the horse racing. And so that's for 15 days of racing, which I'll also mention, we may have 15 days of racing in our proposal, but we have 4 months of horse racing support. We're providing stalling and training services to the industry for 4 months. So we're going to have the entertainment element of 15 days of racing to get the crowd interest, to get the patrons excited. But then we've said to ourselves, with Billy's, it was really his idea and his urging, that his horsemen need more than just 15 days of racing. They need a home, they need a place to train, and so we decided to support that with the additional 4 months of activities.
Well, if we put aside the legal question, which is a fundamental one, but if we just put it aside for a minute, there's a equally large implication to your request, which is what would prevent Plainridge, or Suffolk to come next year, either retroactively or for that year, and ask for monies from the Racehorse Development Fund to use in their operating expenses, because we've already taken the position, whether we had the legal authority or not, that you could do that out of the Racehorse Development Fund monies. That opens the door, in my view, wide open to a real quick depletion of the Racehorse Development Fund, which was never the intention of the original Gaming Act.
I think the answer to that is twofold. The first is, it's all within your discretion. So you'll manage those funds and you'll invest those funds where you believe they should be invested. As to the retroactive element of it, you've already approved their expenses to be paid for or covered through a different vehicle. So no one's going to come back to you, or they can come back to you and ask for a different, a different source of funding. You've already given them what they've asked for. But on a going forward basis, it's all within your discretion. You'll decide what makes sense for the industry, how much support is necessary. I believe that's what the legislature gave you the authority to do. And as the chairman said, that's the legislation and the concept of the legislation that's moving through the House and the Senate today.
Can I just add something? So if we get into those logistics, if Suffolk Downs were to say that they would accept stabling and training of our horses that are in dire need for 4 months, I'd be the first one to jump up to you and please give them the money, because that's what we're lacking. We have an industry that's no longer an industry. We have just a couple of days of racing and people that just don't know where to go. If Suffolk Downs wanted to step up and participate in what they used to participate in, which was the stabling and training, which is our industry, then I would say to the commission, please grant them whatever money at your discretion you can, if it's available. That's the issue at hand, and that's why the discretion of the commission is at hand here. What is it providing? What is that money providing, versus what they're requesting? And I think you have to weigh it and really take a look at it.
Let me ask a question which may reveal my ignorance. If there's no purse account money from simulcast or anything else available now, where's the 225 or the 262 coming from?
Mr. Chairman, Director Lightbaum and I were trying to be fair to both horsemen's groups, to be honest. Legally, if I had to be a very stickler legally, I would have to take the same position and say that can't be tacked on to purse money either. But we really were trying very hard to wrap our heads around what could we do statutorily that would get this up and running. And, we thought that maybe we could do that under the purse account. But I think if it helps the commission to think about it, money goes into a purse account from approximately 4 sources, really. It goes in from simulcasting, live handle, premiums, and in the past, and I don't recommend this, but tracks have oftentimes put money in the purse account themselves. The Racehorse Development Fund came along as a new source of money. And as Director Lightbaum pointed out, we make those payments. The other monies don't ever come through us. We don't see them. But this is something new that was given to us by the legislature.
Right. So absent, the clarifying language that's up in the State House today, even that 262 is a stretch in our reading of the law. So there's no other bucket of money out there that we could have access if we wanted to try to meet some or all of the $1.4 million request. Is that
Not that the commission has access to.
that we have access to?
No, no.
By our interpretation of the law.
That's right.
Well, I hate to say it, but I would love to have you have a chance to try to put together, an argument. And, we're trying to figure out how to say yes, not specifically your proposal, don't misunderstand me. We're trying to figure out how to say yes to flexibility in the Racehorse Development Fund so that we can be supportive of smart strategies to move forward. If we can't get that flexibility, if we can't get yes on that, then we can't get to the question of whether we think that $1.4 million is appropriately spent or not. So if you can figure out a way, short of running up to the State House right now and talking to somebody getting that bill passed, that can persuade us to the contrary, get us yes on the question of flexibility on the Racehorse Development Fund, we're open to it, as I hope you can see. So I, for one, and I guess I set the agenda, so I get to do this, I would be willing to set a meeting next week or whenever, however long you think it's going to take. I don't want to stall this for the reasons of the folks sitting here. This whole thing becomes moot if we don't get this resolved pretty soon. So, how long do you want? And then let me talk with the commissioners as to whether we can do that.
Anytime next week would be fine, Mr. Commissioner. I believe I have one scheduled conflict on the 27th.
What day is that?
I believe it is Wednesday or Thursday. Let me turn on my calendar. Okay.
I think it's a Wednesday.
Okay. Yeah. All right. So are you commissioners willing, assuming we can get a quorum, which I'm sure we can, that we find the time
put that up.
towards the end of next week to deal with this issue?
Absolutely.
Am I missing anything else, Mr. Bedrosian or Ms. Blue or Ms. Lautenbaum? Any other reason not to do that?
No.
I'm unavailable Thursday and Friday,
Okay, well,
but Wednesday, if,
okay, well, I think
So
it's gonna
Wednesday,
be-
we'd have to
I think it's gonna be.
Monday.
I've got conflicts the whole week, but that's my problem. I'll figure that out. And we can, as long as we have a physical quorum, we can have people call in if need be. So we'll figure this out. So we'll work on coming up with a date that we can get get the most number of commissioners in attendance and get back to you.
Thank you, Mr. Chairman.
Is there anything else that we need to do to make this issue as precise and clear as possible? Am I explaining it right, first of all, and are you hearing it right? That the question is, do we have the authority under the law to use Racehorse Development Fund monies for anything other than purses? And secondarily, if so, what? And would that include a track?
Right.
That's the issue, the issues in that sequence that's in
Right.
front of us.
And if so, can you put together a meet as a business proposition with those assumptions?
Right. Okay, then we will be back to you with a date as soon as, just within the next, before the next day or two is up, we'll be back to you with a date.
Thank you, Commissioner.
Okay.
Thank
Okay.
you.
Thank you.
All right, where are we?
Brief break maybe?
Want a quick break? Yeah. I guess is the only thing we have left? No, we had two updates. I think we should go to John's.
It's the ombudsman that
Item
would be
5 is the
next.
big
Yes,
piece left.
that's the big piece
Commissioners'
that's left.
updates could wait if we had to. All right, we'll take a quick break while John gets organized, and we'll reconvene. 95 with the Ombudsman report from Mr. Ziemba.
Thank you, Mr. Chairman and Commissioners. The first item on the agenda today is the review of the applications for the 2016 Community Mitigation Fund. Joining me here today is the review team for this year's program, which includes General Counsel Blue, Chief Financial Officer Derek Lennon, Paralegal Mary Thurlow, and Construction Project Oversight Manager Joe Delaney. The review team has provided recommendations on this year's applications for your review. They're included in your packet. Applicants have been informed that the Commission may accept these recommendations, may reject these recommendations, and may require further information. We're making these recommendations after a very thorough review detailed in your packet, which is being offered in the timetable that was anticipated in the guidelines published last December. You'll see that as of the date today, before the impact of today's recommendations, $14,350,000 remains not reserved or awarded in the Community Mitigation Fund. No additional funds will be put into the fund until full casinos are operational and generating gaming taxes, a portion of which, 6.5% of such taxes, is allocated to the Community Mitigation Fund. In comparison to the funding that will be available after the full casinos are open, resources now are constrained. We note that the greater availability of future dollars makes sense because the majority of impacts are likely after the casinos are operational. Our review today will be organized by the three different categories of funding programs: requests from communities to use 2015-2016 reserve funds, 2016 transportation planning grant applications, and specific impact applications. First, let's look at the requested use of reserve funds. I plan to provide a very brief overview of the requests for reserves, and then we'll break for any questions. If there are no immediate questions, we can move on to the brief overview of the transportation applications, and then a brief overview of the specific impact applications. Following these brief overviews, we can get into more depth on any applications commissioners may want to discuss. Now, we do apologize for the 30-page length of the quote-unquote brief summary in your packets, but as I understand it, there's over 1,000 pages of materials included in your packets today. So we do apologize that, but we'll try to make this brief and understandable. So assuming that that's an acceptable way of proceeding.
John, I just want to, before you get into the specifics, I just want to make a couple of general comments about at least my own view of the Community Mitigation Fund and about this process. You mentioned that this is up for unanticipated expenses. When we talked with the communities, the surrounding communities, we talked a lot about do your jobs thoroughly and well, because the community mitigation, don't think of the Community Mitigation Fund as a fallback where if you don't think about stuff you should have thought about, this is for unanticipated and unanticipatable. Now, that's not an absolute hard and fast rule, but it's a predisposition. we don't know what's going to happen with this community mitigation fund. It seems like it's going to be a lot of money when the thing is up and running and everybody is mature and contributing to it, but we don't know what the demands are going to be. This is a totally new area. There's no such thing as a community mitigation fund in any other jurisdiction where we get some experience. It's very important that we not do anything here that is construed as a precedent that's going to bind us going forward in any way. We're going to make discrete judgments on each of these issues as best we possibly can, knowing what we know, but realizing that there is a whole world here to unfold, and it's for years and years and years this is going to be going on. So we will be retaining the maximum amount of flexibility, and I just want to make that clear to everybody, heads up, particularly people like you who are going to be dealing with this kind of stuff a lot. We're going to try to figure it all out, but we're still at a very early space on our learning curve here, and nobody should construe anything that we do here as binding us going forward other than whatever commitments we make.
Can I mention something? You reminded me of a point I wanted to make to the staff, and it occurs to me it's opportune to make it now. There's clearly a lot of work that you put into this, and it's going to be self-evident by your remarks and some of the questions. The correspondence, the submissions, the correspondence to submit additional information, and so on and so forth. And there's also a lot of information in this meeting in other areas, racing and and regulations. I could barely go through the binder, when it came to me, and there's a lot of, there's fantastic comments that we should think about, permutations of ways to go about, thinking of caps, thinking of, what may be out there. And this is not a comment on the effort, which is substantial. It's just more a cry for help to the staff and our executive director, to the extent that we can get a little bit more further notice on some of the evolution of these conversations, iterations. This is true for racing. It would be that much helpful to me, and I can only imagine to my colleagues, to understand the background, the back and forth, et cetera, because a binder of this size, it's all in here. It's the correspondence, the history, the memos, but I wouldn't want it to be a disservice to our decision making by virtue of having to read this very quickly. So I just think we need to. And I know it's exacerbated perhaps because we have only one meeting this month, and it may be the same case next month. We knew some of that, but it's very hard for me to go through a binder like this in one day, even with the briefings that we get, to make sound decisions.
Right. Another way to say it is we need more time if we can possibly get it on these things. Okay.
In order to amplify the chairman's thinking regarding the precedential value of some of these decisions, I will note that what we plan to do in the future is that we will take advantage of all the resources of the Gaming Policy Advisory Committee and the subcommittee structures to further work through a lot of these very thorny issues. In many ways, some of the questions that are before the commission are questions that have been looked at in all different walks of governmental life. Utility regulation, schools, school funding, housing issues, gentrification issues. Different agencies have taken different approaches to that, and we'll take a look at a lot of those issues. But in many ways, I think over the course of the next few years, people will ask us to, in many ways, take a look at things differently than even well-established policies, and we'll have to make a determination of whether or not we go forward with those recommendations or not. In regard to the timing matter, I apologize for the lateness of the memorandum. We got materials, the application materials to you earlier this year. and gave you copies of the questions and answers as we're going forward, but you have a very good point. This is a very dense memo that didn't get to you until a few days ago. So, we'll work even harder to try to get that to you quicker, so you can evaluate that.
John, just one comment, one additional comment before we start, and I mentioned this to John earlier. As I was going through some of the applications, and some of them look beyond just transportation issues or roadway planning issues. Some start to get into communities wanting to do things along the lines of employment, business opportunities for local businesses with our casinos. And my suggestion to John was for him to consider adding Jill Griffin to the review team so that all of her work is somewhat aligned with what individual communities are doing, and she might be able to bring to bear some resources that those individual communities might not be aware of.
Great.
You picked up on something that I was going to push back on, by the way, and I can do it now or wait for, I don't think that we should be paying those kinds of efforts out of this mitigation fund, but let's get to those applications or those individual examples.
Great. So with that in mind, why don't I proceed in giving you a little bit overview of the reserve requests. As you're aware, we have established $100,000 reserves to 28 communities totaling $2.8 million. Unlike our annual funding round where applicants must apply by February 1st of each year, communities may apply for the use of reserves on a rolling basis once these needs are identified. Pursuant to our guidelines, reserves may be used to cover specific impacts in 2016 or thereafter. A reserve may be used for planning, either to determine how to achieve further benefits from a facility or to avoid or minimize any adverse impacts. What I'm referring to are policies that were included in our 2016 guidelines. After our reviews, our meetings and conference calls, and the follow-up written questions to the communities included in your packet, we believe that all of the still pending applications are consistent with the 2016 guidelines. First, I will describe Lynn's use of reserves, as East Long Meadow has for now withdrawn its application, and Chelsea will be discussing the transportation planning grant application section. Lynn. Lynn plans to use its $100,000 reserves to conduct studies relative to its predominant concern relative to the Wynn Boston Harbor Casino traffic. Lynn is concerned about the impact of both construction and operation-related traffic on its congested roads. Notably, it would like to assess how the city could address congestion through improvements to its roadways on Route 107 and Route 108, Route 1A, the Lynnway, and through alternative modes of travel through potential commuter rail connections and water ferry service. These studies would be based upon analysis that has already been done on the area. Following any commission approval, we recommend that staff work with Lynn on the scope of such studies. The scope for Lynn and other grantees would be part of the grant contract and administrative process. Malden. Malden plans to use the reserve for a portion of the annual salary of a senior planner to work on gaming-related opportunities for Malden. Malden is committed to significant matching funding for the planner, $65,000 to $70,000 per year, versus the $25,000 requested assistance. Malden would use $15,000 for a comprehensive marketing program to promote Wynn-related opportunities for Malden businesses and $10,000 to launch a citizens engagement program to provide employment opportunities for Malden residents. We view this application as directly on point regarding the intent of the reserves to use planning funds to determine how a community may achieve further benefits from the facility that's taken from the 2016 guidelines. These efforts would complement and build.
Was that a quote?
Yep.
Okay.
These efforts would complement and build upon the efforts of the Commission and Jill Griffin, Director of Workforce and Development, to help residents and businesses make the most out of this unique opportunity with Wynn Boston Harbor facility. Indeed, I take, in conversations with Commissioner Stebbins, I think that Jill's participation on our team would be very welcome. It's a large team, but not too large a team, and this is a very important matter. Saugus. Saugus also plans to use $35,000 to assess potential opportunities for Saugus businesses to benefit from the Wynn Boston Harbor facility. While Saugus will focus while Saugus's focus will be to benefit Saugus businesses, it will work with MAPC and the North Shore Economic Development Council and the Commission, as we just discussed with Malden. Saugus requested that the $65,000 balance of the reserve be utilized for the implementation of steps identified in the review. We discussed with Saugus that our approval of such additional work would be more appropriate when such steps are identified. Therefore, we have recommended for now only the $35,000 first phase of Saugus's request.
What's the difference between the 35 and the 65 again?
So if they have $100,000 worth of reserve, they would like to use the full $100,000 for assessment of these business opportunities in order to allow Saugus businesses to take advantage of the opportunity of the wind facility. $35,000 would be available for the initial consultant to determine what are the appropriate steps and what they should do to get organized to take advantage of those opportunities. And then the $65,000 would be, once those steps are identified, to implement those steps. But those steps are not yet identified, since that is the focus of the first part of the study. So therefore, we, and I think with the agreement of Saugus, both believe that that could be a subject of a separate submission to the commission.
In a future year?
No, reserve requests are on a rolling basis. So as soon as they develop their implementation steps, they could forward that to the Ombudsman's office. We would review that, and then we'd put that back before the commission.
So do the 35,000 for the assessment.
Yep.
And come back for the 65,000 when you have the strategies that arise as a result of the assessment.
That's right. And Saugus plans to work, consistent with our regulations with MAPC on, regional opportunities. And obviously, they'll take advantage of guidance that we provide through the commissioners and Jill on how businesses can take advantage statewide. But obviously, the focus with Saugus would be necessarily on Saugus when we created the reserves and created the opportunity for them to use it to try to take advantage of opportunities from the casino. I think that's what we determined, or at least in the guidelines were determined as an allowable use. Rentham plans to use $50,000 of its reserve for a Route 1 corridor study. The focus of the study would determine constraints to development such as zoning, environmental factors, and traffic, and to identify the type of development that would succeed along the corridor. Rentham provided evidence that the Plain Ridge Park Casino is having an impact on increased development in this corridor. Our licensees were requested to provide assistance as part of our, provide their opinions regarding these requests for assistance as part of our application process, and our licensees provided support for all of these applications. So in that regard, before I turn to the transportation planning applications, I'd welcome any questions.
In the spirit of these opportunities, what opportunities are we thinking about when they're operational?
Yeah, when they're operational. So obviously, if they're operational a couple years from now, it may take businesses at least a couple of years to try to get ready for those opportunities. They can understand what wind standards are, what specs they usually call for a lot of their products. I believe that Commissioner Stebbins and Jill have been working on trying to identify what those standards would be, so that we can make sure that Massachusetts businesses take advantage as much of all those opportunities. There were substantial purchases that were included within both WIN and MGM's applications to the commission for a license, that they would try to achieve as much of their purchases locally. This would enable Saugus and other communities to try to take advantage of those opportunities. In addition, there's significant opportunities for employment regionally. WIN has requirements in its agreements that it should try to reach out to those employees. It does, consistent with our outreach requirements. We have quarterly reports. We ask them to tell us about their outreach requirements of what they shall do to try to get employment opportunities for local persons. This would enable communities to continue to try to focus on their citizens in order to take advantage of those opportunities. Jobs, business.
Yeah, let's keep going, because I have other points to make in the other ones. See if we're going to go back by different categories.
Well, are we going to vote on the category, each one or
Vote
each
on this
I
group.
think what I recommended was that I was going to go through by category. I'd take any brief questions on the category. I would then, for efficiency's sake, go on to descriptions of the further grants, take any sort of questions, then go to the final category, the specific impacts, and then obviously we could have a robust discussion by the commission of, general themes, specific applications. If there are specific questions regarding any particular application, we can get into depth regarding any one of those.
Okay.
I would only suggest, John, again, is, in this first group, if we approve this first group, at such time that, correct me if I'm wrong, you actually write a contract for the use of funds with these individual communities. And, be thoughtful, and I don't really need to tell you this, but to be thoughtful of, if Saugus is doing something to talk to Saugus businesses, that they're not doing it in a vacuum, that they have wins expectations in front of them, that, Paul Connolly in licensing is there to talk about what's going to be required of them to do business, so to paint the full picture and not just have it a very narrow silo of conversation, among the, the recipient communities.
It has always been my intention since the beginning, since we crafted the original draft of the guidelines, that local efforts through these funds would build upon everything that the commission is doing. Everything that the commission is doing, our efforts, but it will also build upon whatever regional efforts. You'll see in some of these applications that they do have the outreach to their regional planning agencies and local economic development organizations. But this is a comprehensive whole, at least that's the way that it's been put forward in my mind of how these communities should operate. And we have a tremendous role to try to promote business, and the commission has done a tremendous job, and Jill has done a tremendous job in trying, and Paul and others have done to try to promote their own communities in order to take advantage of these opportunities. There are benefits to the facility. We've been talking about those benefits for the last couple of years. There are potential impacts, and those benefits and those impacts would really accrue to some of the nearby areas to the greatest extent. Hopefully and we know that there are statewide benefits and statewide impacts, but really what we're talking about is some of the more contiguous communities that we hope can benefit as well as we can remedy some of their impacts.
And let me hone in on the notion of impacts. This community mitigation, I really see as mitigating the adverse impacts. I know it's broad to think about it from capitalizing on opportunities as a good impact, but from my memory of all the hearings that we had with all the concerns that we heard from citizens, surrounding communities, number one was always traffic. And there's others, and we need to think about that. I think the opportunities is a good thing to have, where there's an existing infrastructure in local nonprofits, chambers of commerce, et cetera, that and the very active role of the licensees and our own role with, we have funding, for community colleges, local nonprofits that we're doing out of our own budget. That if we fund these local efforts, and I'm not saying there's no role for local people in this effort. The Community Mitigation Fund in these next 2 years is going to grow very thin very quickly. Maybe not right now, but when other communities realize, and it's only a matter of time, that they could fund planners or conveners or local nonprofits to capitalize on opportunities, in my mind, that opens the door to a lot of costs at the expense of what was really a concern and has been always a concern of just about everybody when it comes to traffic, transportation, et cetera, et cetera. So I know that that's on the margin, each one of them is meritorious. A percentage of a planner that is also going to do outreach seems pretty straightforward. But I'm really worried in terms of the precedent setting that opens the door for a real erosion of the bulk of what we have, which we need to preserve until real money comes to this community mitigation fund. So as we go along, I'm going to push back and try to convince my colleagues to not authorize certain of those portions of costs and focus on the ones that are very targeted to transportation issues, for example, and transportation planning, like Chelsea and others, and we'll get into that, because those are very targeted, very localized, and very, in my view, really square along the lines of what mitigation means and the general spirit of the Community Mitigation Fund. I just wanted to mention that, at the get-go.
But one thing I would respond is that I think that over the course of our reviews, we have been very mindful, and communities have been very mindful of the preeminence of transportation items as items of concern for mitigating impacts. But obviously, that is not everything that we've heard. We've heard a lot of other concerns regarding mitigation impacts. In the review team, we discussed the whole point that you just mentioned, Commissioner, which is what is the line between an impact and actually trying to allow communities to proactively try to take advantage of opportunities. And I think what we determined is that they can be viewed in many cases as the flip side of a coin. By taking advantage of opportunities, you can actually prevent some of the negative impacts of loss of business and such other things that we've concerned ourselves. When we created the 2016 fund, we created this category of funding to take advantage of those opportunities. I hear your point, and I think that obviously you have the ability to take a look at these applications in this funding round. I would say that perhaps it should be in the context of the guidelines that we issued in the 2016 program, and that we have many opportunities over the next year, over the next couple years before they're open, and obviously over the 15 years that these facilities are operational, to remedy any potential excess that we may find with communities or others creating such precedential types of applications. But to date, I think that the review team certainly has been trying to be very responsible stewards with these dollars. You'll see the number of applications and the recommendations that we have, and you'll see in some of the analysis of the applications how we've tried to make sure that we constrain ourselves to casino-related impacts. I guess that's what I have to offer on that matter.
Go ahead.
Yeah, can I just ask a procedural question, John? Is there a reason that it wouldn't be more efficient for us to state our opinions, conclusions as to your recommendations on a category-by-category basis? And there's a lot of material here, and you've broken it down very efficiently. For example, this first section is the use of reserve funds. We've just had a discussion about that. Wouldn't it make more sense for us to respond at this point to your recommendations?
We certainly could. There's one exception, which is the city of Chelsea, which has a use of a reserves for transportation purposes that is directly linked to a transportation planning grant, and those two are linked. I've included that in the next section of the review. But if you wanted to move forward on the recommendations on the use of the reserves, we could certainly do that, just noting that reserves are actually a part of the Chelsea application.
I'm just myself.
That might make sense.
Once I go to the second category, I forget about what I was thinking about the first category.
I kind of like that, too. I just want to follow up on what the conversations you were having. I don't want to muddy the waters on precedent. We aren't setting precedents here, so we are not setting precedents here. We're taking these on a case-by-case basis, and we'll see what the future holds. I agree a lot with your comments. I do think we intentionally set up the reserve fund with more flexibility in it. I wouldn't react the same way for proposals outside the reserve fund as I would for the reserve fund. We sort of set that up as a pretty loose package. We even specifically put in that criteria about how do you maximize the benefits as well as minimize the negative consequences. So, I'd be less concerned about that. There's a finite amount of money and was a sort of a different purpose when we set it up. Okay, so let's take Lloyd's suggestion and let's comment. Tell John where we're at on the first package of proposals. Anybody?
Yeah, I think I made a couple of points already. If we're going to go with this category of planning, I mean, I do agree that the reserve was meant to be broad. I can go along with the way it's currently structured. I would offer the following, because I think by any kind of decision we make, it does set a precedent in people's mind, even if we keep repeating, and we will repeat that this is always on
I
a
just don't want
case-by-case
any
basis.
language in the record
Yeah.
that muddies our
Yeah.
assertion.
No, but, and a lot of that is already here, de facto. I would be a lot more comfortable if we had a cap on things like planners, which are effectively, overhead costs,
Even within the reserve category?
even within the reserve. And consultants for the purposes of, of scope. I know you talked about in the abstract, but it's very important that we follow up on, to me, to make sure that that we minimize duplication wherever possible. That at least different communities take the same data if they're going to be studying similar patterns or traffic patterns, for example. I know in the case of Chelsea and Lean, for example, it's very different. They're thinking about different areas, but if where the region can help, where your role can help, the MAPC, et cetera, in terms of consistency, methodology, data sources, to me, that's where we can begin to be very, a little bit more effective on what we fund that does not replicate efforts. I do want to talk about Rentham, because this is the one that's a Category 2 community, and is suggesting to do a study on Route 1. Remind me, wasn't there an agreement from many of the communities around Plain Ridge that we're going to do the one-year look-back funded by Penn? And how does that relate to these requests?
Yes, Commissioner, if, and I understand, I agree that it's a voluminous packet, again, over 1,000 pages, I understand that. If you take a look at the applications, and specifically with Rentham, we sent a note to Rentham and we asked them to conclude whether or not the study that would be conducted as part of the impact analysis by Plain Ridge Park would be duplicative of some of the components of the Rentham analysis. Both Plain Ridge Park, in its response to the commission, said that it would not be duplicative, and also the town of Rentham provided a response to that question, which I can read if you'd like. The proposed study will differ from any impact studies conducted by the Plain Ridge Park Casino as part of its surrounding community agreement, in that it'll be much more wide-ranging and comprehensive. For example, the surrounding community agreement contains a section entitled Impact Studies and Contingent Obligations, in which it details the time frame and scope for various studies for which a developer is responsible to conduct. These studies are limited to tangible and verifiable conditions identified in the baseline studies. The baseline studies were to be conducted 60 days prior to the opening of the casino. The study proposed in the application submitted would analyze conditions and impacts that have arisen since the opening of the casino, as well as the projected impacts in the future. In other words, impacts that are related to the opening of the casino, as well as the projected impacts, in other words, impacts that are related to the casino opening, in addition to direct impacts to the casino. Secondly, the categories listed in the agreement are limited to traffic, public safety, emergency response, and problem gaming. The study that would be contemplated, that would be conducted using the funds, would be more wide-ranging, studying not only traffic impacts, but other related development that have occurred or may occur as a result of the location of the casino. And it goes on. There's a little bit more of a lengthy response, but in essence, the Plain Ridge Park analysis is an impact analysis. This talks about a more wide-ranging, comprehensive study in terms of projected impacts in the future.
Problem gambling? Are they going to study problem gambling in Rentham?
No.
That's
I
part of
think
the
that's
other-
part of the Plain Ridge Park
Part of the look back.
and the look back.
So what is Rentham proposing to study on Route 1?
So if you take a look at the summary,
Which page, John?
page 7 of the summary. The focus of the study would be to determine constraints to development such as zoning, environmental factors, and traffic, as well as to identify the type of development that would succeed along the corridor. In summary.
So it includes traffic. Wasn't Penn going to do a traffic study a year after?
That's correct.
So how is that not duplicative?
Let me go to section number 2 of the Rentham response.
Well, I think it's, the issue that the look back is looking at is casino, consequences of casino traffic and related traffic. What this is looking at, this is more like perspective for the future. This is looking at constraints to development. It's not like remediating the traffic problems. It's like, given what the casino is going to do X, what kind of a constraint does that pose for other development or enhancement or whatever? You know, they're taking another look at Route 1 in terms of, okay, we're going to have a casino, it's going to do whatever it's going to do. How does that impact our potential for development on that strip, negatively or positively?
And as I understand it, John, you have, Rentham has been approached by potential developers looking for development opportunities along Route 1, potentially as a result of the development of the casino and, you know, its close proximity to a number of other, you know, attractions, and trying to figure out zoning correct, environmental issues, as well as maybe what this future development is going to do, not necessarily the Plain Ridge Park traffic, but what constraints are there from additional traffic being generated by the other development opportunities.
That's right. Included within our responses in the application was a letter from a mixed-use retail housing, a number of other components, over, I think, 685,000 square foot development that's being proposed along Route 1. The developer included within the cover letter to us that part of that opportunity was as a result of the siting of the Plain Ridge Park facility. I mentioned some of in the brief summary from Saugus of what they wanted to include, but what Saugus would like to do, they'd like to take a look at a number of different things. It'll take a look at comments on current zoning and land use restrictions.
Saugus or Rentham?
Rentham. Did I say Saugus?
Yeah.
Twice. That's okay.
I apologize. It will offer comments on current zoning and land use restrictions and suggestions for changing the zoning bylaws and other town regulations in order to facilitate appropriate development along the Rentham portion of Route 1.
They're also on Route 1, by the way, just very far apart. So, remind me, there's no funding that came from the Category 2 license to the Community Mitigation Fund in the upfront, did it?
Yes, it did. They're all the same.
On both categories?
All
Out of the 25 million.
Correct.
Out of the 25 million.
or 85 million, they all got distributed the exact same way.
Exact same
The
way.
only difference is the tax on gross gaming revenues.
Yeah.
That's the only difference.
But the community mitigation
Got money
fund
from,
going forward is
will
only
not
out
get
of
any.
two gaming.
Correct.
Just in the interest of time here, we're going to be here for a long, long time. Are you thinking about opposing Rentham, or are you ready
Yeah.
to move on?
No, no, no.
Commissioners, I
I'm
have a
thinking of
3:30
opposing,
conflict,
Rentham,
so
yeah.
I don't want to be rude when I have to step up.
Okay.
Stand up and step out, I'll come back in.
Okay. Anybody else? Questions, comments, issues concerning?
Well, I just note from the summary, which the review team has presented to us, that they quote from Plain Ridge's comment on this, that to this effect: we therefore have no reason to believe that the studies contemplated by the application will be duplicative with the impact studies, and accordingly support the town's request as set forth in the application. And note further the review committee's conclusion that it's well-reasoned and consistent with the 2016 Community Mitigation Fund guidelines.
Any other projects? I am supportive of all these. I think they're all within the range, the reasonable, flexible, reasonable range. You know, I think, as I said, I think we're going to give a lot harder scrutiny to other appropriations, but this, I think, was by definition flexible, and it certainly suits me. So do we need a vote on these? Okay, why don't we
Yes,
move,
you do.
why don't we, sticking with your
Okay.
plan.
Can we take them individually? I want to oppose
Sure.
some and not others.
Sure. Somebody want to just start running through them and set up a series?
Why don't I start? I move that, that we approve the recommendations of the review team as it relates to the LIN's proposed use of the reserve of $100,000 as summarized in the summary memorandum.
Second?
Second.
Discussion? All in favor? Aye.
Aye.
Opposed? The ayes have it unanimously.
Similarly, I propose that we approve the review team's recommendation with regard to Malden's use of reserve of $100,000 as described in the summary memorandum submitted by the review team.
Second? No seconds?
Second.
Discussion? Further discussion?
I'll be opposing it for what I already said on the record about the use of mitigation monies for outreach on business opportunities and marketing, which I believe are better placed on the applicant and some of the other budget items that we have in our own budget.
Yeah, if this were not in the reserve fund, I might share that feeling, but within the reserve fund, I'm cool with it. So, any other comments on this? All in favor of Commissioner McDonald's memo on the Malden acceptance, say aye.
Aye.
Aye. That would be Commissioners Stebbins, Crosby, and McDonald. All opposed?
No.
Commissioner Zuniga. Next.
I move that that we approve the recommendation of the review team as it relates to Saugus's request of the use of reserves in the amount of $35,000 as described in the summary memo that's part of the materials for today's meeting.
Second.
Second.
Further discussion?
Same as before, I'll be opposing it on the same grounds as Malden.
Further discussion? All in favor?
Aye.
That would be Commissioners Stebbins, Crosby, and McDonald. Opposed?
No.
Commissioner Zuniga. Next up.
I further would propose that we approve the recommendation of the review team as it relates to the Rentham proposal as to the use of $50,000 of its reserve account, as described in the summary memorandum submitted by the review team.
Second.
Second.
Further discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously. All right, nice job, everybody.
Are we taking Chelsea on this matter, or is that a rollover to the transportation planning?
It's on transportation plan.
That's okay.
So let's,
Okay, that's next.
all right, you're up, John.
Thank you, Chairman. Next up for consideration is Chelsea. They have proposed a $100,000 use of their reserve and use of $167,000, $150 in a transportation planning grant. Although, actually, let me go back to my notes, give you a little bit more of a background on the transportation planning grants. So, Commissioners, under our guidelines, communities could apply for the cost of planning projects that are clearly related to addressing transportation issues or impacts directly related to the gaming facility. Communities must first expend any reserves before accessing transportation planning grant funds. Transportation planning grant funds may be sought to expand a planning project begun with reserve funds. The joint use of reserves in transportation planning grant funds is characteristic of the Chelsea application. Chelsea's request to utilize its $100,000 reserve and its $167,150 transportation planning grant applications involve the same use, transportation planning, in the same corridor, Beecham Street, William Street. The assessment of existing and future conditions for this corridor under the $100,000 reserve study would be utilized to develop a conceptual plan for this area. Chelsea notes that this corridor serves as an important role for commerce, connecting to commercial and industrial areas in Chelsea and the Lower Broadway District in Everett. Once Wynn is operational, Chelsea believes that this corridor will function as one of the gateways to the casino for patrons, employees, and deliveries, especially including taxis and other livery vehicles. Chelsea also describes significant economic development, public safety, environmental, and transportation benefits that may spring from this effort. Upon questions from the review team, Chelsea identified approximately $15,000 to $20,000 in efficiencies that may be gained by conducting the two studies together. Everett. Everett plans to utilize $100,000 of its
Let's go ahead and do them one by one as we get
Okay.
with them. I'm sort of apropos of, is this, the 100,000 I'm okay with, for the reasons I've said. I think this is, we've got a lot of flexibility here. The 167, is this further, well, first of all, it looks to me like this is more a sort of a prospective, it's really a prospective planning grant, a development grant. Sort of like what we were just talking about on the Route 1 corridor. It's saying, we're gonna have a casino, it's gonna do X. Now that we've got X happening in our community, where do we go from here? What do we do to maximize the future? As opposed to studying the negative impacts and mitigating them. Am I understanding it correctly?
I think in fairness to the previous conversation, certainly there is an element of improvement of conditions in Chelsea. But there's some significant transportation hurdles that Chelsea is experiencing along that corridor. If you've ever traveled that corridor, I'll let Joe give me a little bit more of an amplification. It is riddled with potholes and other issues that affect the ability of people to travel to and through the city of Chelsea. And so you'd have the assessment of the existing conditions under the reserve study, which would then enable it to use, Chelsea then to enable that to go to basically a 25% design plan for the potential improvement of the area to serve both patrons, employees, and some of these livery vehicles that may commute to or through the city of Chelsea. Now, the way that we have taken a look at all of these transportation planning grant applications is that we heard during at least the initial rounds of our conversations with communities how it may make sense to plan now in advance of potential unanticipated impacts. And so obviously we've been through a very robust Section 61 process that involved thousands and thousands of pages for both of these applicants, whereby we are mitigating the impacts as determined through DOT and through us and through others and through the MEPA team to mitigate those impacts that we have identified, as in both Wynn and MGM. They have an incremental amount of new traffic. The Section 61 findings and the MEPA reviews are designed to mitigate that specific impact. What the transportation planning grants would allow us to do would be to plan and to study some of these other areas that may be impacted by the casino so that you could avoid or minimize the lag time between the ability of the commission to react to anything that may be unanticipated that may spring from the facility. So if traffic is is greater than was projected during all of these reviews, and we're experiencing difficulties in and around the region, the theory behind the transportation planning grants is that we could enable ourselves and communities to get better prepared by at least getting some of the data, getting some of the planning studies ready in advance of actual spending of actual dollars on transportation projects, which are very, very costly. So I do agree that, some of the dollars that you're seeing here, they are significant dollars, but the thought is that if we can spend some of these dollars, which are, frankly, de minimis compared to the much larger dollars that it would take to actually pay for some of these bigger construction projects, that is a good use of our limited dollars during the pre-opening period. Because if we open in both MGM and Wynn, and we're experiencing significant difficulties from a transportation perspective, we don't want to be held back through the lack of planning and the lack of our ability to get concrete plans in place so that we can adjust to any sort of contingencies. So that was our initial theory when we created the transportation planning grants function. We always did anticipate that whenever you do some improvements within a community, or you at least design improvements to roadways, that there would be benefits, transportation benefits to that community. So yes, I do, to your point, in regard to how this does relate to our just prior conversation. But whenever you do improve upon a roadway network, there would be improvements for the community and economic development improvements as well.
I think, and just to add on to that, I think in this corridor, it's agreed by everyone that there will be some impacts from the casino. The question is to what level. Chelsea thinks there'll be more impact than MassDOT thought there would be during the Section 61 findings. So they didn't require any specific mitigation for this corridor. But there is agreement that there are impacts on this corridor, and this is now allowing them to take this up to a 25% design level where they can now go to MassDOT and get on the Transportation Improvement Program process and work towards getting funding for that to mitigate those particular issues that they have. Again, will there be ancillary benefits to reconstructing the road? I think absolutely. I don't think anyone would argue that when you improve a road, there are ancillary benefits over and above just simply traffic.
On this one, I happen to find is one of the most meritorious of the submissions. I think this is right up to what was explained by staff and intended by the guidelines. It's prospective. There's a real linkage to the casino. I happen to be familiar with that corridor, and it's very hard to navigate, but a real cut through for that whole area, and a potential access between the airport and the casino, which is not inconsequential traffic accessing it. So, and construction vehicles as well. So this could be very, very timely as well. So I'm in favor of this request.
Anybody else?
I'm not necessarily saying not be in favor of the request. Some of it has to speak to the language, and again, it's more in the summary. Under your recommendation, John, it talks about when Everett facility is operational, it is anticipated that this corridor will see increased use from casino patrons. Now, when Wynn went through their whole, where's the traffic coming from, did this fall within their review, and what percentage of traffic did they estimate? Not the conversation between MassDOT and Chelsea, but, how much is Wynn projecting, or did Wynn's traffic folks project would come out of this corridor?
So along this corridor, and Joe can help me on this, but along this corridor, the traffic was not significant enough for there to be Section 61 findings relative to, or improvements relative to this particular area. Because of the conditions of the roadways, there was a major impediment to the ability of people to travel through the city of Chelsea. And so, one of the questions that we did ask is that there potentially may be some additional traffic once you actually improve those roads that would actually go to the casino from the airport and from other places. And we said, are you mindful that that may increase commuting through your community? And they did note that, but they did note that in any regard, they believe that this corridor will serve as an important commuting place for many vehicles, delivery vehicles, other vehicles, some truck traffic to the facility. And from the perspective of being able to take a look at this more holistically, the ability to spread out some of the impacts on traffic throughout the whole region, so it's not through one or two or three different sources, is a good in and of itself. But again, those calculations are left for a much later day after we have the ability to assess all of the information that we get through studies, that we glean from the long-term working group and what they're going to take a look at. Those big expenditures of dollars remain in the future. But you're right, no, this was not, there wasn't significant mitigation required as part of the Section 61 findings.
Okay.
But given the linkage, proximity, and at least intuition that this could be a thoroughfare that was not required to be studied, a study is, in my opinion, warranted as good use of the transportation planning. That's what the guideline was for.
Under the reserve application, you talk about preparing, and I'm going to delve into your experience in transportation here. Prepare a comprehensive transportation corridor study, assess existing and future traffic conditions. You jump down to the planning grant application, and the terminology is further assess existing conditions and developing a conceptual plan. Down below, you say a final report will be prepared to summarize the major findings of the planning effort. The information contained in the report will form the basis for future funding applications prepared by the city.
Right.
Just for clarification, those future funding applications to us, or as they pursue potential MassDOT funds?
Well, with all of these major projects, I think communities are going to be trying to find places to get funding. But what we're talking about here is enabling Chelsea to come to a point in their design so that they can compete for TIP funds.
Okay.
And so if they get their designs, and I think this has been an impediment for many years for Chelsea being able to compete within the MPO process for a lot of these dollars, is that their designs weren't fully baked. And so when they're trying to compete versus other projects, they aren't really able to do so. So part of what we're doing with these transportation planning grants on both sides of the state is to get applicants to a condition that they can actually go and seek some of these other sources so that there isn't a major focus on the community mitigation fund. But between federal and state sources, traditional transportation sources, the Transportation Development and Infrastructure Fund, which is a very substantial fund that is created by the Gaming Act, and then the Community Mitigation Fund, there's a number of different resources. But as we've discussed earlier today, the Community Mitigation Fund, as Commissioner Zuniga points out, it may be drawn into many different areas in addition to just transportation. There are numerous areas. So part of what we're trying to achieve here is to enable communities, in essence, to sort of help themselves look for funding that is not really coming down just to us, where we will have a limited pot of funds.
Okay. And I know you're probably only summarizing it here, but I have to suggest that the WINS commentary on this Chelsea application is pretty thin. I know you probably have just summarized it here, but
no, part of the challenge is that when we're working with all communities and licensees, I think there's an intent for everybody to work together, and that folks don't necessarily jump to anything that may be critical in the first instance when they're providing.
There's zero incentive for a licensee to oppose a community.
I understand that, and again, I'm reflecting that this is probably, this is John's summary, but it seems like just a good neighbor, cooperative, friendly endorsement, even though you've had cases where licensees have gone into more depth and more detail as to why they supported the application. That's all I'm suggesting.
The summary that's provided is not much of a summary in actuality, but what we did after we received those recommendations is that we had a meeting with the WIN licensee. They were very gracious with their time and resources and their consultants to try to provide more of an overview of how they have reviewed all of these things during the process. So the review team did get a lot more information through those direct dialogue with the applicant than the sentence that you saw here.
Okay.
Others?
I move that we approve the recommendation of the review team with regard to Chelsea's proposed use of reserve of $100,000 and the transportation planning grant of $167,150 as described in the summary memorandum provided to us.
So
Second?
I second that, and just to clarify, it's for a total of 267,000, right? It's,
Right. 100 and then 167.
247.
267.
267, 150.
Yeah,
150.
there's two planning grants, they're using them in conjunction for the same purpose.
Further discussion?
I second that.
That was seconded by Commissioner Zuniga. Further discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously. Next up.
Everett plans to utilize $100,000 of its reserve and $50,000 of transportation planning grant funds for a study to expand the Everett portion of the Northern Strand Community Trail bike path. The study would result in the development of a 25% design for the path. We believe that the study would be valuable in determining how the path could provide further options to access the site for WIN workers and patrons, in addition to providing a regional cycling and pedestrian benefit. The information gleaned by the study would be valuable to the commission in evaluating the benefits of the extension and the overall cost, while Everett determines how to fund construction of this important bike and pedestrian connection. The application has very significant support. One other addition is that the bike path could potentially be a complementary item to the $250,000 study that WIN is paying for to evaluate a pedestrian bridge across over into Somerville, further making connections to Somerville and beyond for pedestrian and bikes.
And I remember very exciting talks and hearings about this prospect for the city. It's the missing link in a series of roadways. There's a lot of enthusiasts about alternative modes of transportation, et cetera. And this was never anticipated in the host community agreement, remind me? There was never a source for these monies?
No, so WIN had requirements to connect up to the pedestrian bike path from DDR on the other side of the railway.
Mhm.
And so they need to connect up. And then there's one link this one link is a missing link that would then further lead to further investment by DDR Gateway in extending it. So the eventual extension could be a combination of a number of entities. So WIN would be required to bring it to its border with the DDR
Facility.
space.
Yep.
And then DDR would then also have to do a connection up to this missing increment. Joe, is that a fair characterization?
Yeah, there's a section underneath Route 16 and that northern piece of the Revere Beach Parkway where they stop the Northern Strand Trail. The Northern Strand Trail goes all the way up to Lynn. So that connection would then would get you down to the Gateway Center. Gateway is required to build a section of it, then WIN's required to build their section. So literally, you're getting a connection from there all the way up as far north as Lynn. In fact, the trail goes beyond there, but it's not paved beyond that point.
And WIN had other commitments to extend bike connections through Sweet Circle and some other obligations along Broadway. And some of those were determined that they're very difficult or dangerous for bikes.
Mm.
And it's not a simple connection. There's railroad tracks to be moved. There's a lot of logistics. There's DCR property, there's railroad property. There's MassDOT property. It's a tough one. But
Hence the
if
study.
they can get that small stretch that they need to do under Route 16, it's going to open up tremendous opportunities.
And one thing that we'll want from this study is, it's difficult to come up with the actual quantifiable benefit of how many patrons and how many employees would actually utilize, but we're hoping for that type of an analysis as part of the study. They have some projections included in the application of the benefits of very significant benefits to the elimination of cars from all of these bike paths. And we would like to know a little bit more about the quantification of the actual casinos and patrons going to the facility.
And of course, the ability to provide a truly protected path. There's a lot of people now that use Sweetser
Broadway.
and Chantilly and all of those to get down Broadway, and it's crazy. Because there's no accommodation through those rotaries. You get a protected connection underneath those roadways. I think a lot more people will use it than try to do that today.
Yeah, this is the rubber hitting the road on all those, high conversations, high-level conversations about alternative modes that make their way, on Sullivan Square and all the working group, and I think this is a very tangible, very exciting, prospect that could open up, a real relief in many modes, in the other modes, which is the car.
Yeah, I think the commission was extremely forward-thinking when it looked at a lot of the conditions with WIN and the evaluation of WIN and focusing on mode share. And,
Yep.
to the degree that we get more and more folks off of the roadways through these additional modes, that just benefits everybody. And so
Right.
to the degree that we can take a look at realistic, targeted investments that are affordable to get folks off of the roadways, that is really the direction that we're hoping to go. And that's hopefully the direction of the long-term working group as well.
I like the fact the city is also stepping up and offering in-kind services of its team to
Right.
help facilitate the completion.
I have to say, unfortunately, that I think that this hits the line, from the reserve 100,000, I wouldn't have a problem with it. The 50K from the, this seems to me to be not mitigating the negative consequences of the casino. This is an enhancement to the community. This is a great idea. I love the idea. And Everett has a ton of money coming in, where other places where they might be able to come up with that 50,000. But this, if it were 5 million, I wouldn't even dream of doing it. It's so small that you're kind of inclined to do it. But I think we're going to have, particularly until we know how much demand there is for this money, we're going to have a hard time distinguishing between enhancing the community and making it a better place versus mitigating the negative consequences, which is the real essential intent, I believe. So, sort of as a matter of principle, I would reluctantly not support the 50. That just doesn't make sense to me, given this tension this distinction that we're trying to make here. Any others you want to set a motion? Make maybe 2 steps, because I'm going to be able to support part and not.
The one,
Well, are there two elements of it? I mean, it's,
So there's, it's $150,000, but consistent with our guidelines, all communities must first expend their reserves
Right.
Before they can utilize transportation planning grant funds. So it's $100,000 out of the reserves and then $50,000 out of the transportation planning grants.
So it's 2. If anybody's going to oppose one of them, we got to do it in 2 motions.
I'm going to support both, but I think there's,
I'm going to support both too, but.
there's such a pragmatic application to this effort, which is why I'm supporting both.
Well, I'll just make the motion of, that we approve the recommendation of the review team with regard to Everett's transportation planning grant of, was it $100,000 from the reserve fund and $50,000 from the transportation planning fund.
Do you want to take those separately?
Well, I can, as long as it's going to pass, I can just make it clear what I'm doing, so. All right.
I second that motion, Commissioner.
The way it frames, I'll have to vote against the whole thing, and
Right.
I'm in favor of 2/3 of it, but, yeah, okay, fine. Second,
I've seconded.
further discussion? All in favor?
Aye.
Commissioners Zunigas, Stebbins, and McDonald, all opposed, nay. Commissioner Crosby. For the reason I said, I think the 100,000, I would definitely support. The 50, I think, is not appropriate. Next up.
Malden. Malden is requesting $100,000 to assess parking capacities and pedestrian safety around public transportation and parking in Malden. Malden is recognized as a transportation hub for the WIN project. WIN will be providing shuttle service from Malden Center for both employees and patrons. Malden wants to assess its parking resources to understand the need and cost for upkeep over the life of the Wynn Casino project, and will assess the need to convert existing lots into parking structures. Malden further identified the need for some redesign work around Malden Station due to traffic impacts and pedestrian and bicycle safety. Given the importance of Malden Center as a transportation hub, we recommend this funding. As with all of these requests, staff will work with Malden on the scope of such efforts and compliance with how funds are expended between Malden's reserve requests and this transportation request.
Same question as before, John. I remember my recollection of the surrounding community agreement, which was, I think, one of the first ones that Wynn signed with Malden, was that there was a significant anticipation of these parking shuttling services. What did they anticipate there that is now insufficient to now make use of these funds?
So if you take a look at the memo, find the page,
14 or
page
13.
13?
14. No, page 13 into 14. So the relevant sections of the Wynn Surrounding Community Agreement. Section 1 of the Surrounding Community Agreement, Malden's recognizes the transportation hub for the project. Wynn will be providing shuttle services from Malden Center for both employees and patrons by buses, trains, water services, or commuter rail services. As a result, public safety upgrades, improved lighting, coordination of transit bodies, as well as additional staffing by the city would be necessary. So there was a one-time upfront payment that the licensee awarded. It was a $500,000 transportation hub payment, and then $325,000 annual transportation hub payment, which is due on or before 90 days following the opening. $100,000 on or before 90 days following the opening, annual THP, and transitional roads payment, one-time upfront date that the licensee is awarded. That $325,000 was available upfront, and then $225,000 annually transitional roads payment.
So they've gotten the $500,000?
Yep. Based on my memory, this summary, and let me just confirm.
Well, should have been 825.
Shall be due upon the date the license is awarded, that $500,000.
Mm-hmm.
So it's 500 plus 325, or is the 325 part of the 500?
So there's 500, which is a one-time upfront payment. The 325
On transitional
is-
roads payment.
The 325 transitional roads payment is due on or before 90 days following the opening of the project. The annual payment, I'd also mentioned $100,000 annual payment of $100,000. That is due on or before the 90th day following the opening of the project.
What is the fourth line?
And then the fourth line, then the transitional roads payment, that, I referenced a roads payment that was upfront. That's a one-time, non-refundable payment of $300,000 due upon the award of the license. And then there's 225 annual transitional roads payment.
Right, so there were two payments up front, 825,
Yep.
for a total of 825,
Oh, I see.
for transportation and for transitional roads.
Yep.
In their request, Malden is characterizing it as what? What do they need? Help with the same thing, being, a transportation hub and part of the transitional roads. So how does the request now complement, or what is now needed that is not part of that 825 rather?
Well, the THB and the TRP, I can read the language of it. They're not prescriptive in terms of what is allowable or not allowable. The THP, the Transportation Hub Payment, this shall include to facilitate public transportation to the project. The parties will explore the use of covered parking facilities within the city of Malden, provide additional off-site parking for WIN employees and/or vendors.
That's specifically, those same words are
Yep.
are in this
Right,
application.
so they anticipated parking being a transportation hub, totally legitimate. And they got a payment for that.
Yes.
They anticipated that there was going to be some roads impacts, they got a payment for that too. Now they want to put pen to paper and are doing some transportation planning. Is it costing them $925,000? So that they're using the 825 first? I guess that's fundamentally my question.
I think probably where you're going is a fair question.
What is the total scope and how are those initial payments, how do we make sure that they're not being duplicated?
Well, and I don't think it would be duplicated. I think, well, you know, all these communities have multiple needs, and they'll
Well,
use the money for
no.
whatever they can, you know. But I'm with you. It seems to me that this was something that was discussed in the surrounding community agreement. It was addressed in the surrounding community agreement. Unless there's something to suggest that the way it was addressed in the surrounding
Was
community agreement
insufficient.
was inadequate, which is not a suggestion here, it does seem like, even, as you say, some of the language is the same. This is on the 60,000. The
Right.
40,000 for the study of the Malden Center area is a whole different story. That's, you know, but it seems to me like the 60 on the face of it, from what, you know, I see here, has been or covered by other considerations. Particularly in the early stages, when I think we need to be very conservative about our judgments here.
Mm-hmm. Particularly that you already awarded a planning grant
All right,
for
so,
Malden.
so as part of our application, Malden was required, as part of the transportation planning grant application, to describe relevant excerpts from the host or surrounding community. And let me just read what they said. I don't know if it is contrary evidence to the questions that you're raising, but it says, as you can see from the language of the surrounding community agreement between the city of Malden and Win Everett below, these impacts were not addressed as part of the agreement to serve potentially as a transportation hub for the casino. Both parties recognize and agree. This is language.
That's the title of the.
As you can see from the language from the surrounding community agreement, these impacts were not addressed as part of the agreement to serve potentially as a transportation hub for the Wynn Casino. Both parties recognize and agree that the city of Malden is uniquely situated to play an important role as a transportation hub for the Wynn Casino development. Both parties agree it is mutually beneficial to work together to capitalize on this infrastructure unique to the city of Malden. This shall include but not be limited to the utilization of Malden Center and BTA Station as a designated shuttle area, the desire by the parties to utilize the city of Malden covered parking facilities to provide off-street parking for Wynn Casino employees, including the running of shuttles. The specifics of such arrangements, if one can be reached, shall be contained in a separate document outlining the terms of such agreement in its entirety.
Read the first sentence one more time.
Well,
And I'm going to stop you there because that's the title of their surrounding community payment.
as you can see from the language of the surrounding community agreement between the city and Malden and Win Everett below, these impacts were not addressed as part of the agreement to serve potentially as a transportation hub for the Wynn Casino.
And what was the antecedent to these impacts?
The impacts is the main section is the impact description. It goes on for 4 paragraphs. Let's see, let me just pull out the appropriate parts. The increased use of the Malden Center MBTA station as a designated shuttle area for both customers and employees will increase the amount of pedestrian trips to and from the station, as well as cause a significant increase in the amount of car traffic to the garages, as well as increased utilization of these facilities. As a result, the city of Malden is most concerned with developing safer connections for all users coming to Win, Mass through Malden. We're looking to receive funding to conduct a study to develop better pedestrian management plan to provide safer bicycle and pedestrian linkage to the station as well as garages. Furthermore, given the expected influx of customers and employees from the proposed gaming facility, the city is in need of assessing its parking facilities and putting together a plan to address the additional demands on the system and the ability of the current facilities to handle the demand. This would include but not limited to a comprehensive assessment around the need, feasibility of possible construction of new parking garages to meet this and future demand.
Can I just,
That-
did you get all that?
That's in the-
Yes, yes, I
Could you,
don't know that I got
Could you
half of
repeat?
that.
I'm just trying to be timely since we've been going on for
Yeah.
quite some time, but I apologize, it's a good point.
That was from the application?
That's from the application.
Okay, so then, sorry to do this, but go back to the descriptions that you gave, it was Commissioner Zuniga's questions on the 500 and the 325. What the application says is the surrounding community agreement did not address the issues that are addressed in this application.
Yeah.
So, but that's the application saying this is a good idea. But I thought I heard you read language in the surrounding community agreement descriptions of the THPs, the transportation hub payments, that did allude to parking and the Malden area and so forth.
Correct, and I think, I've acknowledged that is a fair characterization.
Okay, so what Commissioner Zuniga is getting at, and it sounds like maybe you agree, is that notwithstanding the way the application characterizes the surrounding community agreement, it was intended to accomplish largely what this is asking for.
Upon further review,
Now
I
that you,
think
now
that's
that you.
probably a fair
Right,
characterization.
okay,
Yeah.
okay. All right, so are we ready to vote on Malden?
Yep. I am, unless you want to suggest to go back to them and further refine the scope, if you feel that might be more fair to the city, give them an opportunity to make a case that's not on a misunderstanding, let's say.
I think that makes sense. Part of it is that we're here, and to the best of our ability, we're trying to put forward the case for the communities. As part of our reviews, we put together our letter findings and our letter questions so that in writing they could provide all of those answers to the commission. I don't immediately see an answer to the question that you're asking, and perhaps there's something that I'm missing. But I could go back to the community, we could bring that back to you.
Let me suggest that, because I just don't want to go on the characterization on an application or the title of a payment that is exactly what the application says. Maybe the scope can further clarify that.
Okay.
Because I'm going to also recommend that we perhaps do that on a couple of other applications, by the way.
Okay. So just for the record, I mean, we've now had an example of both our general counsel and our ombudsman working to try to accommodate our constituents' interests. And I think that's the appropriate presumption. But it also, we have our own judgment to exercise. So I think that presumption that you're trying to figure out how to accommodate our constituents' interests is good. But that doesn't mean that we're not going to go ahead and probe. Okay, next up.
Did you want to
So we're just going to
Just
postpone.
postpone on the action?
Postpone.
Yeah,
Go
if
back and
That's your recommendation.
Yep, I
Okay.
think that makes sense.
Okay.
All right, Medford. Let me move some of these 1,000 pages around here.
You're doing great. I don't know how you find those things.
And Mary isn't even assisting me at the time.
I know.
All right. Medford. Medford is seeking a $600,000 allotment of transportation planning grant program for a multi-year, multifaceted transportation planning program. It seeks $240,000 for the cost of a salary of a new transportation planner for 3 years, 3 years' worth of transportation consultant services to assist the planner's work, worth $210,000, and $150,000 for water transportation matching funds. The city identified numerous areas of study by the planners including coordination of city efforts relative to the $1.5 million Wellington Circle update study paid by WIN, study of numerous intersections that Medford believes may be impacted, potentially work related to Medford's proposed water ferry service study, and review of parking-related plans relative to WIN's planned use of Medford's facilities for parking. We note that Medford is due to receive a very significant percentage of wind-related traffic. Although the MEPA process and the traffic mitigation required pursuant to the MEPA process is reflective of the significance of such traffic, we believe that Medford's focus on transportation planning fits squarely within the Commission's purpose for transportation planning grants to enable communities to prepare for impacts which may not have been anticipated. Planning in advance is important, as the Commission has noted. I've gone over this point a little bit before. Planning in advance is important, as the Commission has noted and as Medford has advocated, because transportation planning projects may take many years to develop. While the review team agreed regarding the need for planning funding, we believe a one-year allocation instead of a multi-year allocation is necessary. Specifically, we noted that while the Community Mitigation Fund is extremely important in addressing casino-related matters, it is not a mechanism to fund general municipal activities. Our funding can and should have positive ancillary impacts on municipalities. However, our funding cannot be used to pay for general municipal activities not related to the casino. In this regard, while we believe that Medford could spend 100% of grant funds in the short term on gaming-related planning activities, it is inevitable that such expertise may be called upon to address non-gaming related matters in the municipality. We believe that the cost of such non-gaming activities should be borne by Medford. Thus, while we could pay for 100% of first-year activities, we would request that Medford reapply for future years' funding and include in its applications the likely percentage of the planner activities that would relate to the casino. The city would need to certify that its use of CMF funding, community mitigation funding, relates to the casino. As we recommend, we recommend one-year funding of the planner and associated consultant costs prorated to when they're likely to begin. In addition to the planner, Medford requests $150,000 as a match for a $750,000 earmark for the study of a water ferry service that could connect to the wind facility. We recommend this study as it could prove to lead to the development of a new important alternative transit connection to the wind facility. Staff will work with Medford on the scope of the study to ensure that it includes connections to the wind facility. Our funding would be dependent upon approval of the overall study by MassDOT and federal partners.
You know, I have a different suggestion that might end up being very similar in terms of funding, and may help us with precedent setting or not going forward. I would be a lot more comfortable funding a third of a planner, for example, assuming that, which is effectively what we did. We did that just a few minutes ago for, I'm going to forget the city. Was it? Wherever it was. Malden, right. If we were to roughly assume that the city can kick in, the city or the municipality can kick in another third, and there would be other sources, federal or state, let's say, for these purposes, or maybe the person is already there, or something like that, may help us in bringing having the city more of a longer-term approach to this. Aside from 1 year, it would be too unfortunate that that we fund the full position in a year and somehow there's no funding, or we decide there's other priorities the next year, and then the position is terminated, for example. When it comes to planning, I know that I've stated my opinion relative to funding this, and if it's in a shared way, I'd be a lot more comfortable.
So Commissioner, in anticipation of your question, back in June, we asked the city of Medford to react to how we treated a similar request in Mansfield, where we paid a percentage of the overall costs of the planner. And in your packet, I don't know the page.
Page 984.
Page 984, subset B, clause 1A. Their response was as follows, because as you know, Commissioner Stebbins and others, Commissioner Zuniga has asked for communities to provide significant matching funds for any of these activities. And so in their response, the city, to our question of this utilization of this model, where we pay a certain percentage of the planning activities, they noted that the city of Medford may provide office space and oversight of the planner if the position is a public position and serves a public purpose. The intention of the transportation planner, separate from the gaming commission, or WIN, is to have a position that serves the public interest. The city will not contribute planning funds unless planning funds can be received from a grant source. So I think what, and as is indicated in our memo, at least not immediately, the city of Medford would not have the ability to contribute further funds in this regard from their response.
Other reactions? I had this, we in the briefing conversation with John, I was persuaded that Wellington Circle isn't as big a deal as Sullivan Square, but it's the next one. Wellington Circle is a bad place, and there's going to be a lot of stuff going on there. And to anticipate that essentially everything the planner does in the first year or so is going to be focused on that or related issues makes sense. So I'm comfortable with funding doing this. This does seem like it's in further response to mitigate negative consequences, to understand, to go further than the surrounding community agreement is done. So I'm comfortable with the first year of the planner. The water shuttle, again, water ferry, although I think it's a great idea, I hope it happens, doesn't seem to me, it's small money, it's like the other thing we talked about earlier, but as a matter of principle, this seems like an enhancement. It's a great thing to do, but it's not mitigating a negative effect of the casino. Maybe if one were built, it might divert a little traffic, which would be good, but that's just a nice thing to do. It's not mitigating a presently unmitigated negative. So I would not be supportive of the water ferry, again, this early on when we don't know how conservative we're going to have to be, but I would be supportive of the planner.
I'll let some of my other team members pipe in some or all of these matters, but.
Would you like to take a break?
Let me take a shot at it as we go on. So in regard to the ferry, again, we had a pretty robust discussion about how we're really focusing on mode share, and we're trying to get more vehicles off the roads by focusing on alternative methods of transportation. Wellington Station is Station Landing is one of the potential major areas of departure for patrons, for employees, and there could potentially be opportunities whereby Station Landing is included in the scope of this study, that folks could get off at Station Landing, jump on the ferry, and go directly to the wind facility. And so that it might actually, or some of the employees, if they park at that place, it could be rather quick connection to the wind facility. But Joe, let me let you amplify that.
No, I think that captures it really, is that this is a way that had not been considered before to get some traffic off the roads. This was just, the earmark that they received is an older earmark, but now with the casino, they're looking at modifying the scope to say, hey, this is another way to do this thing. And for them, it's also potentially, it brings some people into, they're looking at Malden Center as another location, Medford Center is another location for this, for the boat and other things. So I think it's a good opportunity to get some traffic off the roads that would otherwise be going down Broadway or on Route 16 or other places.
But again, one thing that we're making clear now is that studies are studies. Funding for services, that is certainly a later date. And one thing that I know that the Medford folks will study is, can this actually survive without major subsidies or significant subsidies from government? And, we've made that clear as a concern. Can they do it on their own? Is there enough benefit up and down the line? Our dollars on the water study would not be available unless and until MassDOT goes along with the scope of the study. So to the degree that they also have concerns regarding how we expend limited dollars on ferry services, that would be all part of the mix as well.
Say that last piece one more time, please. Our monies will not be available until,
Our monies will not be available until the other dollars are available pursuant to the earmark.
Earmarks,
the
And so
750 from
So
DOT.
they have to get the scope for the 750 approved. When we first started going over this with the city of Medford, it looked like the 750 remaining portion of the earmark would be more readily available than at the current moment. Medford noted in its response to us that it is working more fully on the scope with MassDOT, where MassDOT wants them to take a look at utilizing certain consultants that have experience on transportation matters. And so there's going to be a final approval of scope by MassDOT. We would have to approve the scope as well on the water transportation study to make sure that it is directly related to the casino.
so the 750 is an earmark from MassDOT for water transportation?
Yes. And ours would be the state match for
The
that
state
federal
match
earmark.
for the federal earmark.
I mean,
Could you pull up the Community Mitigation Act language in the statute?
So, John, what is the bottom line of the recommendation with regard to at least the next year?
So in regard to the next year, we recommended that we could fund a full 1 year's worth of a planner, part-time or full-time, that the city would have to certify to us that all of the activities that are paid for relate to the casino. In order to access any future funding for a transportation planner, its application would need to go into some detail regarding what percentage of the activities of that planner would be casino-related, anything that is general municipal-related. Medford would have to demonstrate that it has the resources to pay for that planner. But all of this would be contingent upon what we do for the 2017 Community Mitigation Fund guidelines. And so the fact that transportation planning grants are included there now, it's not a foregone conclusion that they would be included in the next year's program.
So help me understand, the consultant services, the 210,
Yes.
and the water transportation matching funds, 150.
Yep.
Over what period of time are they anticipated?
So those were 3 years, and so what we have done is that we prorated if you take a look at the memo
Yeah.
Yeah.
on page,
Prorated the consultants and the planner
we prorated the
and added in
consultants, so
150.
it's $240,000 for 3 years' worth of the planner. 1 year's worth of the planner would be $80,000. I think it would, I'm trying to find the page, but if my memory, it would take them at least 3 months to hire the planner. So we prorated that portion for the rest of the fiscal year, so they would only get a portion of that $80,000 for the remaining portion. And then, to the best of my memory, Medford estimated that it would not hire any consultants for another couple of months after that it would hire its planner. So we recommended $50,000 for those consultants. $40,000 represents the prorated portion of 210 divided by 3 year, the prorated portion of the fiscal year. For that, it came down to $40,000. We were a little bit generous because just because you have 3 years of planning activities, sometimes you may want to do a little bit more at the beginning versus at the end. So we did, or I did, recommended putting an additional $10,000 more on that planning activity for the first year.
so what's
The
So
total
it's
would,
prorated planner and consultants plus 150.
plus 150?
So the total value, including the $150,000, equals $267,000.
But how likely, wouldn't we be in a very uncomfortable position of denying a second year if they had already funded the first year?
Yes.
So this is effectively a 3-year request that's just being quantified as the first year.
No, he's being very explicit to them, saying, we're going to recommend that we support you for 1 year. Very likely will not recommend that we support you going forward. You'll have to, going forward in future years, document what % of your hours is on casino-related work, and that you've got the wherewithal to pay the balance. He's been very
That's
explicit
right.
about that.
That's right.
So they might think they can suck us in, but they can't.
You know, and given this conversation as well, it might be in their best interest to get as much as they possibly can out of that planner in that year one, and especially where we anticipate that 100% of the funding should be for that purpose.
Right.
Knowing that there's no certainties in life, might be a good idea to do a lot in the first year.
John?
Do you have it, Catherine?
Do you have, what's,
Oh, okay.
I have it.
Oh. Great, thank you.
Mr. Chair, while you're reading that, John, help me understand the consultant services that they're hoping to.
So I'm going to let Joe get into a little more detail. They gave us some substance of what they were thinking about when we met with them, or when we had our conference call with them. In the answer to our question of what you would utilize the additional service, the additional consultants for, they said that the scope of such consultants would need to be determined after the hiring of the transportation planner. But, you know, similar to what we do, you know, we have some staff expertise, but we do reach out for more specific studies that you might involve more specificity, such as, you know, roadway counts or things similar to that.
Yeah, they identified in their application 12 intersections that they wanted to do further study on. Some of them were studied under the WIN EIR, but most of them weren't. And they're looking at those intersections saying, well, we think, you know, they're signalized intersections, we think that they need to be retimed and reconfigured, perhaps restriped, you know, for extra lanes and other things. You'd need a consultant to come in to do those traffic counts, turning movement counts, things of that nature, to lay out what the solutions are. Until you have that data, you can't really do that. And, you know, the transportation planners typically that are hired by cities and towns don't have the equipment to do these kinds of counts, nor the staff. I mean, these turning movement counts are still done by hand with people sitting at a street corner with a, you know, with a computer counting cars. So anyway, there are certainly legitimate uses for a consultant to assist the transportation planner in trying to solve the problems that they're looking at. But the exact scope of that would need to be determined once the transportation planner was on board.
And, you know, on the water transportation, maybe I view it a little bit differently, you know, even though you did raise the issue of it's an older earmark. So, you know, I'd be in favor of obviously conditioning the 150 and making sure the 750 is still available. But I think, John, to your point, you know, this could be a successful strategy in terms of getting more people off the road and to use other modes of transportation. And when you look at the surrounding community agreement, WIN actually steps up and says, you know, we'll pay money for, you know, operating some type of, you know, ferry service or, you know, the water shuttle service or whatever it is to draw people out of the Medford location. So I would look at that as maybe a smart use of money in terms of, you know, an additional opportunity to kind of mitigate traffic and, you know, find alternative access ways for folks.
I think that's exactly spot on. In our review, we specified that we would require the study to continue to include station landing inlets analysis, but also include the analysis of the connections directly to the WIN Casino. And it could accomplish exactly what you're talking about.
Well, this, as I said, I think the ferry is a terrific idea, but the statute says about the Community Mitigation Fund that we, quote, shall expend monies in the fund to assist the host and surrounding communities in offsetting costs related to the construction and operation of a gaming establishment. And then it gives all the categories. So it's offsetting costs related to the construction and operation of a gaming establishment. And, you know, I'm sure we've thought a hell of a lot more about this now than they did when they wrote this, but I think it's pretty clear that they were talking about mitigating negative effects, negative consequences, which they were going to have to fund, that were not otherwise funded. And I think we have probably the flexibility here to construe this more broadly if it turns out that there is monies available in the future to do it. But as we start out, I think we need to adhere as hard as we can, given that these are very gray decisions. And as an example, the water ferry does not fall under a rigorous reading of this language.
But I think you also need to look at how we define transportation planning monies for this round of mitigation funding.
In addition.
But we
you know,
can't define it outside the law. We got to define it within the parameters of the statute.
I would posit that we are countering negative impacts. One of the biggest impacts from facilities is, to communities, to all communities, is the potential of additional traffic on roadways. And to the extent that we're expending monies to analyze how we get more additional cars off the roadways, we are spending monies to offsetting costs related to the facility. It's not, only direct costs, but it's costs in a larger sense of what are the impacts to a community. And it's hence the Community Mitigation Fund to mitigate impacts to the facility.
That was exactly the case I was making against funding people reaching out to businesses out of the community mitigation. I know you interpreted it as very flexible in terms of the planning reserve, but that was precisely my point,
Yeah, well,
to try to narrow it to what was agreed by everybody, that transportation, now, funding an alternative mode, we can disagree on that, but, transportation concerns was the top priority of just about everybody.
This is a really tough one, because another reading of this would, cost, as you say, John, does not have to be you wrote a check.
Right.
One cost is the damage done by a car driving to the casino.
Right.
So if you could offset that cost by putting the person on a ferry. So,
Right.
There's another way to read this, which would make it flexible. So I don't know, there's no right or wrong here.
Right.
These are just tough calls. I go back and forth between wanting to be rigorous up front, restrictive up front, so that we don't get ourselves in trouble by having not enough money to do the job on the one hand, and on the other hand, wanting to support creative, thoughtful, positive, in the biggest extension of the word, mitigation of the effects.
There's another, you just made me think of another sort of risk. We have, by necessity, we are doing what needs to be done, which is thinking about planning. And there's going to be a lot of planning in different areas, water, Wellington Circle, et cetera. But then there's going to be the question about funding, and which we're not going to be able to fund out of the Community Mitigation Fund.
Right.
This is in many cases, a state issue and a DOT and even perhaps a federal question. So there's the risk of having all these studies, but then there's really just, one or two areas that realistically all the stakeholders are going to be able to come and coalesce around. In the sense that a study may end up sitting, in all of our desks for a long time. I don't know which one is that going to be, and it's very hard to predict. But the risk of studying multiple things now is that many of them will just be that study. And so whenever we have a doubt as to, the sources, the amount, through that lens, we should, I might argue, we should err on deferring until later the ones that seem less compelling now.
Yeah.
Because we will have less flexibility if we had spent the money.
Yeah.
And that, so for whether it's the water or whether it's the definition of mitigation, in the aggregate and in each one of these, I'd like to, think about decreasing some of these amounts or staying until further scope is understood or until the next year of funding is more clear and we have a better sense of what's in the pipeline.
Commissioner, I think you're talking about something in my old world when I spent time at transportation.
I know.
Something
I
we
know you
struggled
have-
with
right.
all the time of how much money you dedicate towards studies versus for some of your actually concrete projects. And we talked about how if there are unanticipated impacts, we want to be ready to go right away, and to have the studies done makes sense. But every once in a while, you have these fall from the sky moments. And I remember when the federal stimulus bill was passed.
ARA, yep.
Was the state in the best position to take advantage of those dollars with shovel-ready projects? And I hope we never have a circumstance where an ARA is necessary, but federal dollars becoming available for infrastructure, it might just be a necessity at some point, given the constraints that all states are experiencing. But now we're going afield to a whole other area.
Right.
No,
Well,
that's-
John,
that's
apropos of
fascinating.
these, the chairman's point and Commissioner Zuniga's, and I don't have them in front of me here, but do the guidelines, the community mitigation guidelines that you have been proceeding pursuant to, do they address this issue as that has been raised here?
Yeah, when we developed the guidelines in this past December, we anticipated that we were undertaking these planning activities for potential future unanticipated impacts, and that was why we were trying to do that. Obviously, we're not spending money duplicative of the mitigation that's already been required by the state. The state has made a stance that mitigation pursuant to Section 61 is the impacts that are identified today. But part of what we're trying to do with transportation dollars and these study dollars is to anticipate, or at least get ready, things that we might have to take a look at in the abstract from all sources of funding.
But Commissioner, to ease your minds, competitive grant processes, guidelines change from year to year. You don't have to fund everything that's in that statute on 1 year. You can change up pieces of it. You can decide that this year, yeah, we did some planning. Next year, we're going to cut back on that. But based on how the guidelines were written this year, a lot of these applications conform to them. So they applied based on what we had written as what we would like to receive for funding opportunity. And that's what we evaluated it based on. If you're having concerns, we can change that in future years. We can limit that. We can expand it. We can say we're going to target this one area in future years. And 75% of the funding that we set aside will go towards that. That's the beauty of a competitive grant application. And if you want expanded meetings on what the guidelines should be and what we'd like to open up competitive applications for, that's something. But this is kind of
Right. Well, I think that's.
over the top.
I
right
think
now.
that's a part of our whole review of everything. I think that's a good idea. You guys probably know a lot more about it now, and at some point, not too distant future, we probably ought to rethink those regs, rethink those guidelines.
Correct.
Guidelines.
Well, that was kind of, it was behind my point, is that I read your recommendations here in the context of having reviewed the guidelines that have been shared with the applicants. And it struck me as that your recommendations here were consistent with a conclusion that the applicants' proposals were ones that were consistent with the guidelines that had been shared with them. A little concerned we might be shifting the criteria at the last moment somewhat unfairly on the applicants.
I'm kind of leaning towards that thought process. If we take a look at the whole, if we approved everything that's recommended, it's $1.8 million of $14.5 million. It's 1/7 for what's going to be a 3-year process. It's pretty modest, in the big picture. And given that this is our first round, given that it is pretty much compatible with our with our guidelines, albeit maybe we would change them, happy to do it over again, I kind of lean towards, let's go with it. If this were $8 million, I'd say, I'm not sure, not first year out, that doesn't make sense. But under 2, I mean, maybe that's a fairer way to go.
I have a figure like that. I've thought of it, remember there's 28 communities that are either a host surrounding or neighboring community in the state, which does not include the Region C, which we have not talked about. If you take the 14 million that we have and divide them by 22, it's about a $500,000 per community. And if you take that over more than 1 year, say 2 years, we have and this is a very, very rough proxy, we have a $250,000 per community per year. And which, if we go down the path of finding planners by community, funding planners by community, and funding studies by community, we can get there very quickly. And for every one of the requests that is more than 250 per year now, again, proxy, rough, that means, there's less capacity for any one of the other communities. So.
Well, yeah, and we really don't. We have barely over 250 on 2 of them. So we've basically fallen within your guideline here.
Except that some of them are thinking about multi-years.
Yeah.
We'll get to,
Oh, you
the
said
sheriff,
250
250 per year, per community,
Yeah, 250, okay, yeah, so.
which includes 100,000 for the planning grants, which we've reserved for everybody.
All right, so where are we? So on Medford, do we have any more conversation about pre-vote on the Medford recommendation of around 80,000 for the better part, from a planner, 50,000 for consultants, and 150 for the waters?
Are you opposing any one of them, or?
I don't think I'm going to be in favor of all of them, I think. I changed my mind.
Then that's fine.
And maybe this just came up because of some of the things that Joe talked about. Now I get a little less comfortable with some of the, we've gone through a process where WIN is evaluated as part of its MEPA review, a number of intersections. And correct me if I'm not reflecting your comments appropriately. Now the city wants to go back, look at some intersections that weren't covered, and talk about traffic signal changes, more lanes, everything else. As well as a number of the other activities that they point to down here. And I don't know, just, maybe I'm overthinking it, but I'm just thinking of.
We're definitely overthinking this.
We're
No
definitely
question.
overthinking this.
No question about it.
We wouldn't still be sitting here.
Well, I think the point is that, there were a number of intersections that were originally proposed.
Right.
That number was cut down.
Right.
As the process went through.
But they were cut down for a reason.
They were.
Okay.
But they were on the same corridors
Okay.
that we're talking about. They evaluated this one intersection at one end and another intersection at the other, but there's 3 more signalized intersections in between. In order to do corrections at the other ones, you have to look at the ones in between as well.
Right.
And now, MassDOT, again, this is that same thing that we had with Chelsea. MassDOT and Medford disagreed with how much traffic they expected on those, and they're saying, well, these 2 signalized intersections at each end, we're saying that we don't need to do anything with them, because the level of service drops a little bit, but not enough to require mitigation.
That's what DOT said.
That's what DOT says
Right.
under their Section 61 finding.
Right.
And Medford's saying, we don't agree with that at all. We think they all need mitigation. Now, they're saying here now is that we want to do some additional study to see what we can do to all of those intersections to improve the flow of traffic through there. And in doing so, it will certainly help the city, but it will also help the flow of traffic that's going to the casino as well. I mean, there's ancillary benefits from everything that you do.
But judging the flow of traffic to a casino that hasn't opened its doors yet.
Well, understood. Again, these are planning studies. These are not trying to address actual impacts. They're trying to anticipate the impacts and see what they can do to be ready for when the facility opens or In certain cases, it'll be much longer term than that. You know, many of these design projects that, you know, the Chelsea project is an example, maybe a multi-year design project. You know, they might be ready to break ground when the facility opens, or a year after, whatever it is.
And part of our approach has been fairly conservative in the eyes of some in the outside world, where folks would like to utilize a lot of these funds for the actual hard construction of some of these projects right now. And our focus has been, you know, we don't know what we don't know as of yet. And before you make major decisions regarding major allocation of dollars, this was a reasonable interim step, given the lead time for transportation projects of years before they can become ready for construction.
Okay.
Well, John, so that maybe we can bring to closure this discussion of Medford, could you state, you know, again, for the record, what the review team's recommendation is as to the next year's commitment of these funds?
So we recommend that, that the commission authorize $267,000 in one-year funding for the city of Medford for the provision of transportation planner services, in addition to consultant services as delineated in the commission's packet, the memorandum from the review team. Such funding would include $150,000 for a water transportation study. The staff will be instructed to work with the city of Medford through the grant contract process, so that they understand that future applications, it would be necessary to identify what specific allocation of transportation planning dollars would be necessary for gaming-related versus general municipal activities.
And the water transportation would be contingent on obtaining the earmark.
Obtaining the earmark, and would contingent upon inclusion of gaming-related stops such as station landing and the wind facility.
I move that we approve the review team's recommendation as just summarized by John.
Second.
Further discussion? Nope. Promise? All in favor?
Aye.
Opposed? The ayes have it unanimously. Now, it's 20 minutes of 5. We've got West Springfield, we've got 3 more to go. We'll never get them done by 5. I have a relatively hard stop at 5. I think a lot of us probably have soft to hard stops at 5, if not before. We could keep trugging, but we've already decided we're going to have another meeting for the racehorse issue in sometime in the next week or so. I'm kind of leaning towards postponing these until, and then including, as well as the topic I didn't get to do, which is the commission reports.
Maybe we could just finalize the West Springfield Transportation Grant,
Okay.
planning grant, close those out.
And I'm just wondering also, the three observers back here, you've been waiting patiently. Are you here on a specific item?
Oh, you're here, oh, West Springfield.
All right.
And you're probably here for the fun of it, I know. Right. I know, you turned your clock off hours ago. You're just here for fun.
Oh, no, we didn't.
Yeah. Yeah, if we can.
Can we do West
Yeah,
Springfield?
let's try to do West Springfield.
Okay, great.
Sorry, Jonathan.
No problem.
Could have done that first, sorry.
West Springfield is requesting $247,500 for the design and permitting of a project to reconstruct Memorial Ave, which it notes will be impacted due to the close proximity to the MGM Springfield project. West Springfield received $665,000 for such design in its surrounding community agreement, which resulted from an arbitration with MGM Springfield. The request is an overage to the original cost of the study. We believe that this overage is reasonable. The overage results from some delays in timing, and also results from the inclusion of a complete streets design concept. The complete streets design concept would enable West Springfield to more effectively compete for limited transportation dollars, as the complete design is a standard that was more fully developed after the arbitration, and it is the standard of the day. It includes taking a look at pedestrian transportation, all access of transportation requests. We believe that the overage is reasonable, and very sufficient detail has been provided by West Springfield.
Is this a multi-year study?
This is a design, and this is a one-time design, and this funding results from, it's the additional cost to the funds that were allocated by the arbitrator in the arbitration. At the time, they provided a reasonable estimate of what that funding would be. This represents the additional cost over and above there, plus the contingency regarding.
And those additional costs are because they now have better estimates or bids or?
Yep, so they now have better estimates from bids, and also that the design work will include the complete streets design concept, which is a standard that is now standard with Mass DOT planning. So in order to develop the design of the Memorial Ave project, which is in concert with the state's complete streets design concept, West Springfield would be in a better position to compete for these limited transportation dollars because their project would be designed in accordance with the standards that receive funding.
Yeah, and just to add on to that, the 665 of the arbitration was done just based on an estimate.
Yep.
From an engineer this is about what it'll cost to do it. They went out to bid, it came in higher, and then there's that higher number plus the complete streets element added more to that. But based on the estimated construction cost, it certainly is a reasonable fee for design. And it will take more than 1 year to complete. These, it has to go 25, 75, 100% design. They have to be design hearings and things of that nature. So it's a longer process, but it is, they have a single contract with a single designer for that amount of money. So this just makes that contract whole.
He's not asking how long it's going to take. He's asking, are they going to come back for another round of money? And you're
All right, no.
Well, no, it was implicit in my question too, that, these, however long this takes, and it's likely to take more than 1 year, by making a commitment, we're making a commitment, now in this amount, we're making a commitment that's going to take care of the actual design, regardless of how long it takes.
Right.
It may be more than 1 year.
Do I understand correctly that, John, that you probably, if they'd known these facts at the time of the negotiation, they probably would have got that money included in the surrounding community agreement? That would be
One
consistent.
can never know from what an arbitrator would do, but they provided an estimate. The arbitrators used that estimate when
Right.
making their finding, had they been presented with this additional information.
Seems kind of fairly logical.
Yep.
Yeah.
And the arbitrator in this case sided with West Springfield, right?
West Springfield won. Yep.
Yep. Sounds good to me.
Mr. Chairman, I move that we approve the recommendation of the review team for $246,000 in transportation planning grant funds to assist the town of West Springfield with the design cost of Memorial Avenue Complete Streets design.
Second?
Second.
It's always good to leave your proposal until the end of the day when everybody's so tired they couldn't possibly resist. Any further discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously. How are you doing? You all right? All right, so I think we've agreed that we will pick the rest of this up on whatever day we do our other meeting. John, that was a tour de force. Thank you very much.
Yes.
You and your team have done an incredible amount of work, and whether it looks like it or not, we really appreciate it.
Thank you.
Yes, thank you.
Thanks.
I think as a final item of business, we ought to all acknowledge our stenographer,
Yeah.
who has been going solidly for the last 4.5 hours.
Yeah. Thank you.
I move that we adjourn this meeting, Mr. Chairman.
Second?
Second.
All in favor? Aye. All right.